But, I have filed an IA, my lord, on 9th of February, my lord. May I pray for listing of the matter on 15th, my lord,
15. 15 is what?
Thursday.
Friday.
Lord.
A poor lady has applied for Basundhara scheme, my lord. And there's also a protection given by the Honorable Court that till disposal, my lord, that application she should not be evicted from the, my lord, the premises, my lord. Now, my lord, in a sudden manner, my lord, that authority has dismantled one portion of the house without any so-called nothing has been issued. We have been made the personally the party respondent therein. Lordship, now they have threatened that the rest portion they will also, my lord, dismantle, my lord. Some urgency there, my lord. It is totally case of, my lord, that because of the political consideration, only that lady has been evicted, my lord. Lordship, I pray this matter can be taken up, my lord, 2 p.m. Lordship permits.
Already dismantled tomorrow.
No, my lord, half portion.
Tomorrow.
Tomorrow, my lord. And another matter also, my lord, is eviction matter. Tomorrow, my lord.
What eviction?
My lord, that matter is, my lord, pertinent to AIDC, my lord, where, my lord, that I'm representing AIDC, my lord. Here, my lord, we have already issued an eviction notice. But question since 2022, they are protecting their interest, my lord, and nothing they have paid, my lord. Now, my lord,
Normal course.
my lord, deeply.
Normal course.
Deeply.
May it please, Your Lordship. My lord, I beg to mention item number 38, Your Lordship. Maybe adjourn for 2 weeks, Your Lordship, with similar matter, Your Lordship, WBC number 7335 of 2023.
No, this is High Court matter.
Lordship.
Not similar matter. How can it be similar matter? Single post.
Because they have also
Single
challenged
post.
they have also challenged the termination.
That is different thing.
Lordship.
How can it be? You have applied for single post.
Lordship, great.
You want adjournment
38.
or what?
Lordship,
You want adjournment.
adjourn.
Mr. A.A. Diwan, Learned Counsel for the petitioner, has sought adjournment of the case for 2 weeks. Mr.
N.K. Sharma, lord.
N.K. Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel, ZHC, is present and has no objection to said prayer. The prayer is allowed. Please the case after 2 weeks. Please pay up.
Deeply obliged, lord.
Much obliged, Lordship.
Maybe this is I beg to mention for listening for admission, my lord.
What is the subject matter?
Regarding the removal secretary of cooperative society.
Hmm?
Removal secretary of cooperative society.
No agency. Pursue before the registry.
Lordship, I beg to mention item number 21. The advocate on record, Mr. R. Senso, is currently out of station and
21.
yes, sir. Maybe.
Motion.
Yes, sir.
Hmm? Okay, on the prayer of Mr.
G. Kaushik.
G. Kaushik, Learned Counsel appearing for Mr. R. Sensuo,
Maybe listed after a week.
Learned Counsel for the petitioner. The case is for pass over court. Mr. R. Borbujari, Learned Standing Counsel Revenue, and Mr. N. Goswami, Learned Junior Government Advocate Assam for the state respondents.
I'm obliged.
May your lordship, WBC number 6169/2023. It's mentioning for early listing of the matter, your lordship. For early listing of the matter.
What is the subject matter?
It is land matter, your lordship.
Land matter means what?
This land was being donated by the petitioner, by the mother of the petitioner.
When was it? When it was listed last?
Last 17/11/23. Much obliged.
Would like to mention item number 22 motion matter, your lordship. I have instruction to withdraw this petition with liberty to file a fresh, your lordship.
Mr. M.H. Roscoe, Learned Counsel for the petitioner, has submitted that he has instruction to withdraw the petition with the liberty to file a fresh. Mr. R. Borbujari, Learned Standing Counsel Revenue Department, and Mr. N. Goswami, Learned Junior Government Advocate Assam for the State respondents are present and have no objection to state fair. In view of the above submission made by Mr. Loskar and counsel for the petitioner, the petition is dismissed on withdrawal, with the liberty, as paid for.
I am with the.
May I please prepare for listing of admission matter any day next week or day after.
What is the subject matter?
Regarding the IAY lordship, petitioners are not receiving
What?
petitioner's name in the list of IAY, Indira was regional lordship earlier, but they are not allowing to getting any IAY now lordship. Official rejected their name lordship. Any next week or day.
Your Lordship, I am on behalf of Mr. H.R. Chaudhary. Kindly matter may be, I beg to mention item number 40, kindly matter may be
Item
passed.
number
40,
40.
yes. Matter may be passed over the date.
Okay, on the prayer of Mr. MS. Your name,
H.R. Chaudhary Act,
your name,
A.S. Pradhani.
A.S. Pradhani, Learned Counsel appearing for H.R. Chaudhary, Learned Counsel for the petition. The case is passed over for the day and Goswami Learned General for the respondent is present.
Please, my lord. My lord, I'm praying for listing of an IA civil for impeachment of the state respondent, your lordship. Can it kindly be listed tomorrow, your lordship?
Not tomorrow, Friday.
The main matter,
Already tagged. Till
main
Friday,
matter is
Friday.
on Friday, my lord.
Friday.
My lord, and there are two other writ petitions, your lordship, fresh matters. Can they be taken up on Friday? Filed
You
in,
pursue the matter before the registry. It will be listed. Why not?
we have, your lordship, but we have actually, there's some staff crunch, I believe.
Huh?
There's some crunch in the writ petition section, your lordship. So that is why, if it can be taken up on Friday. Most obliged.
For motion item number 1.
This is your lordship. Lordship, in this matter, I am in possession of 20
You are
without.
making mention or you are moving the
I one lordship, I am moving the case.
Okay.
Lord. In this matter, I am in possession of 20 bigha of patta land covered by DAG number 415 and patta number 81. So lordship comes to annexure 1 series that starts from page 31 onwards. These are the land documents of my land, lordship, patta land. This was
Annexer.
annexure 1 series. It starts from page 31, lordship. This land was on 15/6/31,
31.
lordship. So on 15/6/2011, the secretary in charge of the revenue department of Karbi Anglong Autonomous Council settled 20 bighas of land in my name and favor. Serial number 1, Manoj Hasnu, lordship.
Annual patta.
Yes, annual patta basis, lordship. Thereafter, lordship, after this settlement has been done, lordship comes to page 33. There, in the annual patta, my name has been incorporated, and all the other relevant documents as Chitta, Jamabundi, and the non-encumbrance certificate as well has been annexed in this series, lordship. And I have been regularly paying the khajna also, lordship, before the concerned authorities, lordship. So what happened in this matter is, lordship, the Karbi Anglong Autonomous Council, actually the NHIDCL, National Highway, they are widening the National Highway number 29 in KAC. So in that matter, lordship, they appointed the respondent number 3, the Joint Secretary of the Revenue Department, as the competent authority for land acquisition. So initially now, lordship, if your lordship comes to annexure 2 series, the respondent authorities, page 48 it starts, lordship. Annexure 2 series, the respondent authorities,
Annexer 2.
2 series.
48 is give deed, some give deed.
Lordship, sorry, lordship may come from page 52 onwards, lordship, annexure 2 series. So the respondent authorities demarcated the land schedule through which the national highway will be widened. Therein, your lordship will come to the extreme right of the initial map, lordship. This is prepared by the competent authority for the land acquisition in January 2021.
Page 52.
Yes, lordship. Mohendijua Forest, lordship, has got it in the extreme right. Lordship, below your lordship will see periodic patta number 81. NC area, then periodic below Mohendijua Forest, NC area, and then
Page 53.
52, lordship. Lordship, this is 53 is like better, lordship. Then that was the sketch map prepared by hand. 53 was the map prepared by the respondent authorities. The yellow portion marks out the land through which the national highway will be extended, and your lordship will come and see 415 patta number 81 on the right hand side of page 53. So, out of 20 acres of my land, some portion will be taken away for construction or widening of the national highway, lordship.
How much?
Lordship, that is not yet demarcated. I'll come to that, lordship. Because thereafter, lordship, after this, what happened? The competent
What is
authority.
54?
Yes, lordship, that is the land schedule document in serial number 20. My land has been shown, lordship. And next, what happened, lordship? In the meantime,
What is 415 within bracket R?
R is a reserved land, they say, lordship.
Reserve.
Yeah. It's not. So then what happened, lordship? Till here, everything was fine. Page 55, the annexure 3, lordship. Only in regards to my area of land and some other portions of land, another sketch map. This is an undated sketch map prepared by the respondent number 3. Herein, lordship will see the 415 DAG number 415 and patta number 81 has been converted without giving me any notice, nothing. Has been shown as 693, 694, 695 and 696. These four are relevant.
69?
693, 694, 695 and 696, lordship. These DAG numbers, unknown DAG numbers, have been substituted against my patta land. So thereafter, what happened, lordship? And notification under 3 of the National Highways Act was issued by the respondent authorities, lordship. Therein, in place of annexure 4 is that in place of my land, this page number 59, if a lordship comes, my land is in Mohendijua, block number 4. Yes, yes, lordship. Page Mohendijua, block number 4 is your lordship. Second lordship. There, instead of my land, lordship, that number 693, 94, 95, and 96 were substituted, lordship. When we came to know about this, we immediately preferred a representation, lordship. That your lordship will find it in annexure 5. This was preferred to the respondent number 5, the general manager of NHIDCL. Page 61 onwards, lordship. Lordship. This was my representation asking them to correct the unknown DAG numbers, which were shown in place of my patta land, lordship. Thereafter, this was forwarded by the respondent number 5 to the competent authority for land acquisition, lordship. That your lordship will find at 63, and to the principal secretary also. So yes, like the general manager forwarded these documents like once on 28/3/2022, then to the principal secretary on 9/4/2022, page 64, then again to the principal secretary on 19/4. So this process was, and thereafter again on 4/5/2022 to the competent authority. So while this process was going on, nothing was done. Thereafter, the 3D notification came up, lordship. That 3D notification excluded all the lands. Neither my land was included, nor those 4 DAG numbers, 693, 94, 95, and 96 were there. That is at annexure 8, lordship. Annexure 7, page 67. So that thereafter, what happened, lordship? We preferred a writ petition since nothing was done about a representation to correct the said things. So we preferred a writ petition, lordship. That writ petition was numbered as WPC number 4191 of 2022. Start from page 73. So this writ petition on the motion stage itself was disposed of by this honorable court. Lordship may come to page 75, the operative portion of the order, lordship. In view of the above, lordship, in view of the above, and as agreed to by this writ petition is been disposed of at this stage of motion hearing by granting 2 weeks time to the petitioner to submit a detailed representation along with a certified copy of this over or before the respondent number 3 ventilating his grievance in the matter. Is such a representation submitted within time period provided by this court, the same be looked into and be disposed of by a speaking order after carrying out proper spot verification upon due consultation of the relevant revenue records within a period of 6 weeks. Until the above exercise is complete, no payment shall be made in respect of the plot of land claimed by the petitioner. With those directions, this petition was closed. Thereafter, we preferred our representation as directed by this honorable court on 36, Annexure 9, Lordship. We preferred our representation, Lordship. This representation we gave on 36, but thereafter, the respondent authorities were to take a pass a speaking order after 6 weeks of receiving our representation. But since nothing was done, we preferred a contempt petition, Lordship. The contempt petition's order is at page 83. While this contempt petition was pending, Lordship, the impugned speaking order was passed by the respondent number 3. That your Lordship will find at page 80. On 21/6/2023. Now, if your Lordship goes through this order, the second paragraph, Lordship, herein this second paragraph clearly states that the representation given by us was registered as case number so and so, 12 of 2022, and the original revenue records were called from the circle officer, Lordship. And the respondent authorities herein say that after verifying the original land revenue records, those 20 bighas of land, it has been found that my name has been mutated on 18/7/2011. Herein, I would like to point out, Lordship, out of this 20 bighas of land, I have voluntarily gifted those gift deeds that your Lordship saw on Annexure 1 series, 2 bighas, 2 kothas, 10 lesas of land to 2 persons. So here they say, and accordingly, those names were mutated. So till here, Lordship, it is fine. Thereafter, your Lordship may come to the next page, 81, Lordship. Regarding the unknown DUG numbers, in pursuance of the direction, Lordship, again, the third paragraph of page 81. In pursuance of the direction issued by the undersigned, joint verification of the land covered by DUG number, so this is not after that, of Mohenjo NC and DUG number 693, 694, 95, 96 of village Mohenjo 98 and 99 of village Mohenjo block number 4 was carried out by the officials of Revenue and Forest Department of KSE on 10/6, and joint verification report to the undersigned was on 2/6/2020. In this report, it has been stated that DUG number 693, 94, 95, 96, 98, and 99 of village Mohenjo block number 4 falls under Jamuna DCRF. In the revenue records above mentioned, DUG numbers are recorded as forest land. DUG number 415 is not reflected in the land acquisition plan prepared jointly by the NHIDCL, that Annexure 2 series map that I shown your Lordship. There my land is stated, Revenue Department. So they say that the same portion of land, as per the revenue records, it belongs to me and also to the Forest Department, Lordship. So in the second part of the speaking order, they say that, Lordship, it starts from the last paragraph of page 81. It appears from the notification of village Mohenjo that the land covered by DUG number of village Mohenjo was not within the land required to be acquired for NH29. On-site verification made on 1/6/2023, along with the officials of Diffu Revenue Circle and Forest Department of KSE, it appears that DUG number 415, village Mohenjo, Moja Borjan under Diffu Revenue Circle is not in the land acquisition plan prepared jointly by DPR consultation of NHIDCL revenue staff of KSE. So therefore, they say that another verification will take place. So Lordship, why are we before this Lordship is there? The same portion of land, once they have said that it belongs to me, that 20. Secondly, they again say that that land belongs to the Forest Department. And the third thing is that, Lordship, they say that in the land acquisition plan prepared by the respondent authorities, my patta land was not shown, which is totally contrary to Annexure 2 series that I have just shown to your Lordship before coming to here. So the law regarding passing of speaking order is that it has to satisfy certain principles, Lordship, so that the person who is affected doesn't come out aggrieved again from there. So in this regards, I'll just pray before your Lordship, let the respondent authorities file an affidavit, Lordship, and clarify as to under what circumstances they have passed this speaking order wherein they say one plot of land belongs to 2 entities, to me also and the Forest Department, Lordship. And this is being done, Lordship. Why? Because I have been instructed that a fresh 3A notification will come into effect. So if this speaking order stands and it is not corrected, Lordship, they might again include those unknown DUG numbers in the 3A notification, which will deprive me of my legal rights under 308 to receive compensation. I am, Lordship, not challenging the process of acquisition, nothing, Lordship. I am just on the fact that this revenue records has to be construed as per the records available in the office, and it is a patta land, and I have annexed all the documents, Lordship. So there is no question of the land belonging to the forest department also and as well as me also. So therefore, the speaking order is not in tune with the principles of law, Lordship, and that is why I am before your Lordship.
They are not denying that 415 DAG number is not in existence.
No, they are not denying. They say as per original revenue, it belongs to me, Lordship. The problem is that same portion of land has been shown to be belonging to the forest department also, Lordship.
As on that, even if it is assumed that this 415
Yes, Lordship.
is converted to DAG number 393, 394, 395, 396
693, Lordship.
or 693.
Yes, Lordship.
Those are not still under declaration.
Yes, Lordship. Because the 3D notification excluded all the land and its validity is for 12 months. So now it has
Gone.
expired.
Hmm.
So new 3 years to come in
Hmm.
for acquiring the land over there. And if this speaking order survives, Lordship, they might again include the unknown DAG numbers, Lordship. So let them file an affidavit and show on what basis they have said.
No, they are contemplating some joint verification.
That has been contemplated on 21/6/2023 as
Ah.
per the till that nothing has been done, Lordship.
So if everything comes out in joint verification that your DAG number 415 is in existence,
Yes, Lordship.
then what problem we will have?
Lordship, then it will get clarified whether that 415 and 693, 694 and 6956.
If they say that 415 DAG number is in existence,
Yes, Lordship.
and but there is nothing with regard to acquisition or something like that,
Yes.
then you have no grievance.
Then I don't have any grievance, Lordship. For that effect, I'm saying, Lordship, let them file an affidavit and clarify.
Why?
which part
If
of-
the joint verification report is contemplated,
Yes.
then if joint verification report is completed, then why repetition is
No,
required?
no report has been filed, Lordship, till then.
Joint verification report
one
it
more
was
thing, Lordship,
ordered
I'd
on
like-
21/6/2023, Mr. Sutia.
My lord, before that, lordship may look into page 34. Periodic pata, my lord. The basic things, my lord. Periodic pata, lordship, my lord. Page 34. My lord, in a vernacular, my lord.
Hmm.
Lordship, village. The pata is in respect of Mohendi Jua, my lord.
Mohendi Jua, yes.
My lord. And he contemplated, my lord, contention of the petitioner is in respect of the Mohendi Jua block number 4. There are two different villages, my lord. There are two different revenue villages. One is Mohendijua, another is Mohendijua block number 4. Mohendijua block number 4 falls under, my lord, that portion that has been, which the publication has been under section 3A, that has been under the forest area. So there is no question of acquisition. But the acquisition of the land of the petitioner of Mohendijua is required, my lord. Then the joint verification is required. That other part, my lord, that has already been published in the 3A, but that has been deleted from the 3D. No acquisition plan for that particular those land, my lord.
Block 4.
Block 4, my lord. But in respect of the Mohendijua village, my lord, 3A notification has already been published. His DAG number is not there. He annexed that 3, my lord, petitioner annexed, not he. Petitioner, sorry, my lord. Petitioner annexed 4, page 56, my lord. It is, my lord, his contents in his village, Mohendijua, page 57. There is a different village, Mohendijua, village Mohendijua. Page 57,
Mohendi Jua.
Mohendijua, my lord.
Okay,
His-
Mohendi Jua, block 1,
Block
block
four,
number
block
1,
five.
block number 4, block number 5.
My lord, different
There are
blocks are
many
there.
villages.
Block number 1.
Mohendi Jua.
As per the periodic pata, his village is Mohendijua, my lord. And DAG number 415 not reflected in the LAP, not in the 3A, my lord. If that land is required, then joint verification is required. Whether it is under the LAP or not, my lord, that is required to be, my lord, verified by the jointly by the NSADCL and my lord, Kala.
From this document,
Yes,
it
sir.
appears
Yes.
there are many villages by the name of
Yes, Mohendi. Yes.
Mohendi Jua, Simple,
Block number 1, block number
Simpliciter,
yes.
Mohendi Jua, block number 1,
1, 2,
4,
5.
5.
Yes, Lordship.
Now this Dag number is block number 4.
Yes, sir.
693, 694, 695, 696.
Yes, Lordship.
Right?
Yes.
Now your let us see your patta.
Yes, Lordship.
Mohendi Jua non-K. Dag number 415,
Yes, Lordship.
20 bigha.
Yes, Lordship.
So if there are 2 villages,
3 villages.
3, 4
More
villages,
than that, Lordship, there are 6, 7 blocks.
page 38 also Mohendi Jua non-K.
Yes.
But notification is clear in the sense that Mohendi Jua block 1, these are revenue villages.
Yes, Lordship.
Village.
Lordship, clarify that, Lordship, that I would like to draw your Lordship's attention to Annexure 2 series prepared by the respondent authorities. Therein, the highway is clearly shown going through Mohendijua block number 4, Dag number 415. It is at page number, Lordship may come to once again at page number 53.
60?
53, Lordship. I have shown it, Lordship, earlier, but 53. Lordship, 53 on the right-hand side corner, Lordship. The yellow markings on the left, it is saying that is the land acquisition plan. Yellow portion is the land acquisition plan through which the highway will be extended. It keeps on going. Mohendijua is a large,
This 53 is document of
prepared by the
authority?
respondent authorities, Lordship. The signs are also there. The NHIDCL also prepared it, and the
My lord,
competent-
whether it is a draft or, my lord, I have to take instruction, my lord, whether it is the.
So
general
there it
document or
is
not.
clearly there, Lordship. The problem arose thereafter. The
See,
respondent competent of
if Mohendi Jua
yes,
and Mohendi Jua block 4
yes,
are 2 different supposed villages.
yes, Lordship.
And your land
Yes, Lord.
measuring 20 bigha covered by Dag number 415
Yes, Lord.
falls in Mohendi Jua
Yes.
only.
Yes,
If that is not part of the acquisition plan,
yes, Lordship.
then there is no issue.
It is, Lordship, as per the map, Lordship. It is Mohendija block. That is why I am before your Lordship. It is a very genuine prayer, Lordship. The map they have prepared, I have not prepared this map, Lordship. The earlier 52 also is the map.
Because page 81,
Yes, Lordship.
second or third paragraph, in pursuance of the direction.
Yes. Where the 693 and all are said, Lordship.
Let Sutia place this
Lord.
joint verification
Lord.
report.
My lord, no, my lord, the joint
Yes, so
verification,
that will do, Lordship.
the joint verification, my lord, subsequent after our order, my lord, whether joint verification has been carried out or not joint.
No,
my
no,
lord.
page 81,
No, the
third paragraph.
yes, Lord. Because
In pursuance, that paragraph starting with in
my lord,
pursuance of the
my lord.
direction.
My lord,
See, fourth line.
my lord,
The joint verification report was submitted to the undersigned on
My
so
lord.
and so. In
My
the
lord.
report, it has been stated that Dag number 693 so and so, so and so. Mohendijua block number 4 falls
My
under Jamuna DCRM.
my lord, my lord. My
And in the other hand, in the revenue records, above
Hmm.
mentioned Dag numbers are recorded as forest land.
lord.
Next.
My lord, my lord.
415 of village Mohendijua is not reflected in the land acquisition plan prepared by the
My lord,
jointly by the so and so.
my lord, my
I think joint verification
Yes, my lord.
report would
My-
finish
my-
the issue.
my lord,
Yes.
my lord, my lord.
Lordship
And
along.
second last part is that if 415 is
Required to be
contemplated,
acquired. My lord,
then only they will.
my lord.
Press
My
joint
lord,
verification.
phrase, 3 notification, phrase 3 notification is
If
required.
these 2 villages are different
My
and
lord.
the Dag numbers of the petitioner and all these forest lands
My lord,
are different,
my lord,
then there is no
Yes,
cause of action
my
No,
lord.
True.
My
to
lord.
maintain the repetition.
Yes,
My
true,
lord.
Lord.
As
And
simple
if
as
it is
that.
required, my lord, if it is required within the LAP, my lord, land acquisition plan, his Dag number, then the 3 notification is required. to be
Right,
issued, my
but
lord.
first
That is-
the confusion that the council for the petitioner is saying
My lord.
that Dag number 415 has been converted to Dag number
My
693,
lord, that is my,
694,
my lord,
with showing these diagrams.
my lord, my lord.
That is the only issue.
That is, that issue, my lord, on my standing in the 35 years, I have verified the original settlement records. It is regarded as a, my lord, government land. That those 693, 694, my lord. I have personally verified that land, my lord. I can produce the record also, my lord, to that, my lord. And the
This
lordship may urge-
693, these are also out of the declaration
are
now.
out of the
as on
declaration
date.
now, my lord.
As
There is
on date.
nothing.
Yes.
Only, my lord, 415 of Mohendijua village is required under the LAP, or the land highway will go through that line or not, my lord. My lord.
Then
That is
since,
so, my lord, then
since neither 693, 694, 695, 696
My
are not there,
not there,
and neither 415 is there,
my lord.
then let them file a representation
My lord,
to seeking clarification
Lordship,
that these are DAG numbers 493
693. Or 415.
Mohendojua Block 4
Hmm.
and 415 of Mohendojua are one and the same or different.
My lord.
That's
And
all.
if it is
Lordship, after
different,
this,
That's all.
yes, my-
If it is different,
we have
Then
prepared the
the-
representation. Nothing has been done after the speaking order has been passed. I have an
if it is different,
my lord.
Yes.
If
Then-
it is different, my lord, then the acquisition, if it is,
All the-
highway goes through his land, my lord,
and
then
that should
acquisition
be
plan is-
that should be decided on the basis of land revenue record.
Record.
Yes.
And he
Yes,
can
it's
also,
true.
my lord, lordship may
And-
allow him to look into the records also, my lord.
And also petitioner should be given the opportunity to look into the
my
records.
lord.
Thereafter, if you have a cause of action,
Then, my
you
lord.
come.
Hmm.
If it is in the speaking order, he says
Yeah.
that 493, 494, 495, 496 of Mohendojua block number 4 are different and from DAG number 415 of Mohendojua.
Mohendijua block.
And
Oh, sorry.
Mohendojua.
Sorry.
Your DAG is Mohendojua, NC.
Yes.
Those are in Mohendojua block 4.
Yes.
If those are different from one another and located at different places,
Then there is no question of me
coming,
attending this.
keeping a writ petition
No, no,
pending.
No, Lordship, but after the speaking order was passed, Lordship may see Annexure 12. We have preferred a representation already on 24/8.
Okay.
Nothing has been done. So thereafter, we.
Only issue is this only.
Yes, Lord. And one
That's
more
all.
thing, Lordship. The initial, while in the earlier writ petition was
If
disposed.
you come to if they declare
Yes,
these 4 DAG numbers
yes,
are different from 415,
yes, Lordship. I have no case.
you have no case.
Yes, that I know. That I know.
That's all.
Yes.
Everything else.
So just a short affidavit, let them file, Lordship.
No, why?
Because already
On the basis
representation
of
has been-
record, if the declaration comes from them,
Yes,
you cannot ask to acquire your land.
yes. No, I cannot, Lord, obviously.
And the declaration comes from them,
Yes.
finding comes from them that these DAG numbers are different
Yes.
and differently located.
Lordship, there are
That's all.
two reports.
No question of maintaining a writ petition.
Yes, two reports were considered, Lordship, while passing the speaking order.
No,
For-
your grievance is that only
Yes, yes, Lord.
415 has been converted to 693 to
Yes,
696.
Yes, yes, yes.
If that is not correct,
Yes,
if they say,
yes.
what is left?
That is why affidavit.
What is left?
Lordship, an affidavit to clarify
Why?
what was
If
the.
a speaking order is passed by a competent revenue authority, what is left?
Lordship, what was the.
Why you are interested in maintaining a writ
Lordship,
petition?
the joint
Lordship
verification.
may
report,
allow him
Lordship.
to look into the original records also, my lord. We are ready to, my lord, he can look into the, he can come, he can.
And one
participate in
more
that.
thing, Lordship, what happened, that's just once, like page 80.
We are not concerned with land acquisition process.
Yes,
We
yes,
are
no,
concerned with whether 415 is converted to 693 to 696.
Yes, Lord.
If that is not, and both the plots of land are differently located,
Yes, Lord.
matter ends.
Yes. Lordship, and just.
No issue.
Nowadays, my lord, GPS is
If
also there.
thereafter,
Yes.
if the declaration comes from them, if still you have grievance,
Then we
it
can
is
approach
open.
this. Yes, sir. But one thing just I'd like to point out, before passing the speaking order, we gave them all the original documents. And while the contempt case was disposed of, Lordship, may just come to page.
On the basis of revenue records.
Yes, no, the original documents have not been returned to me till date. The original documents earlier I submitted pursuant to the first writ petition, while I preferred the representation, Lordship. That was converted into an LAC case, Lordship, land acquisition. So then I submitted my original all land documents before the respondent authorities. Till that has not really.
If it is there, if you have
Page
submitted,
84 clearly
if it
reflects.
is submitted.
My lord, what is happens, my lord? We are not contemplating to send it to the, my lord, police, my lord, as he has submitted two documents. Lordship, we are looking to page 80, last paragraph.
We were not. into
My
that.
lord, so my lord,
You
Lordship,
want to
so
file
Lordship,
FIR,
that,
you
that
file
decision
FIR
has
if
not
you
yet
want.
been taken, my lord, to send it to my lord, the police, my lord, for.
Then you seize as per law.
Yes, they should have seen, not they
Madam,
give the.
You
law-
want to seize any document of the petitioner is seized as per law.
My
But
lord,
we are not into that.
my lord, so my lord,
From the,
regarding.
from the grounds agitated in this writ petition,
My lord, my lord.
only question is to be
My
decided,
lord.
415.
For manipulation of the document, submission
not
of
into that.
manipulating document, my lord, whether.
We are not
have
into that.
My lord, my lord. If he is insisting on that, my lord, then we have to take action on that, my lord.
If any document
They are always
is available
available
with the,
take action, Lordship. They can.
Then, my lord, if
Is-
my learned
if-
friend agrees, my lord,
Mr. Sutia, if
submitting that.
any available as he has claimed,
my
if
lord,
any original document
my lord,
was submitted by the petitioner during the process of that case,
which is manipulated,
1 minute,
my lord.
then petitioner will make an application for return
My lord, my
and
lord,
you will consider as per law.
as per, my lord, yeah. If he's
You
insisting
will
on
consider
that,
as per law. If you
my lord.
think that some
Yes,
FIR is necessary,
yes, my lord.
Yes, yes.
if
That will
court
file
is
it.
not advising
My
you.
lord, my lord. If the petitioner,
Mr.
my lord,
Sutia is there to advise KAC.
my lord, my lord. So it comes to me, my lord, out of the record, it comes to me, my lord. So it is not yet done, my lord. But if he is insisting, we can send it to the, my lord, police.
Will not record,
My lord,
will
my lord.
only record that petitioner claims that he is the owner
My-
of DAG number 415,
My
Patta
lord.
number 81. Why, Mr. You are narrating in paragraph 4 that Mohenjo Dua block number 4?
Lordship, it is because it is not reflected in the patta. It is actually
Whatever
Mohenjo
is
block number
Patta,
4.
we'll go
So
only
that
by
uh,
is
the
why that
Patta.
is whatever Lordship wishes.
We'll only go by the Patta.
Yes.
Like, he will submit a representative to Kala, my lord, not the principal secretary. It is the highway act, my lord. Kala is the authority, not the
No,
principal.
Mr. We are into revenue only.
Yes.
My lord, so he should file,
Not Kala. Kala, we are not concerned with Kala.
my lord, then secretary,
To whom you have submitted?
principal secretary, my lord.
No, Lordship.
Yes,
This is the
86.
principal secretary. I have submitted to others also.
No, who is the authority? Revenue authority.
Revenue, joint secretary, my lord.
He is not as a Kala.
Kala.
He has a, he
Revenue
has
also,
to
my lord. Or secretary revenue is also
consider it
there,
as a joint secretary revenue,
my lord, not as a Kala.
not as a
My
Kala.
lord.
Yes.
Most of heard Mr. MP Choudhury, learned counsel for the petitioner. Revenue, Mr. Revenue.
No, Lordship, I think, Madam, I respond number 7.
Who is the standing counsel revenue? Okay, and board of the Wikido. Standing counsel revenue department for the respondent number 1.
So when.
J. Sutia, learned standing counsel Karbi Anglong Autonomous Council for the respondent number 2, 3, 4,
2, 3, 4, 6.
6. Who is for 5? MS.
Tinlong on behalf of RK Talukdar.
Your name, please.
Tinlong.
Huh? Tinglong. Tinglong. On behalf of
RK Talukdar.
representing Mr. R.K. Talukdar, learned standing counsel NHIDCL for the respondent number 5, and Mr. J. Hendik, learned junior government advocate Assam for the respondent number 7.
Same one.
Para. The petitioner has approached this court by this petition with a grievance that primarily with a grievance that his a plot of land primarily with a grievance that in an acquisition process and land acquisition process under the provisions of the National Highways Act 1956 is being undertaken for the purpose of building within bracket widening stroke 4 laning page 67 etc. Maintenance management and operation of National Highway number 29 and during the said process, his periodic patta land has been converted to dark numbers were converted to lands within the forest area. Full stop. Para. The petitioner has claimed that petitioner was allotted 20 bighas of land by the respondent KAAC by an order dated 15/6/2011 at Mohenjo-Dua NC at village Mohenjo-Dua NC by the respondent KAAC by an order dated 15/6/2011. Full stop. Subsequently, a periodic patta number 81 was issued in favor of the petitioner on 30/12/2019.
2019, Lord.
19. Stating that the plot of land measuring 20 bighas is covered by DAC number 415 and periodic patta number 1, which is located at village Mohenjo-Dua non-K NON K no NC Moja Borjan number 3, district Karbi Anglong. Accordingly, name of the petitioner stood reflected in the Jamabandi for Jamabandi within bracket records of right and Sitha. By notification number S O 5192 within bracket E dated 14/12/2021. Comma. The Ministry of Road Transport and Highways, Government of India. Indicated, notified that the plots of land, comma, described therein, comma, would be required for building, within bracket, widening stroke 2 lane with paved soldier stroke 4 laning, etc. Yes, 56, huh? Comma, maintenance, comma, management and operation of National Highway number 29 in the states of land from AM full stop 113 plus 830 to KM full stop 145 plus 712 within bracket package number 6 bracket close within bracket Karbi Anglong Autonomous Council Department of Revenue Depot bracket close in the district of Karbi Anglong under subsection 1 of section 3A of the National Highways Act. Postal. Amongst the plots of land included in the said notification. Sorry. Dag number, the plots of land covered by dag number 693, comma, dag number 694, comma, dag number 695, and dag number 696. Situate at village Mohendi Jua block number 4 were included amongst the plots of land sought to be acquired by the said notification dated 14/12/2021. Issued under section 3(1) within bracket A of the 1956 Act. With the issuance of notification, comma, after issuance of the notification, after issuance of the said notification, comma, the petitioner made correspondences with the respondent authorities to know as to whether his periodic Pata land, comma, covered by dag number 415 and Pata number 81, comma, situated Mohenjo-dua, village Mohenjo-dua, was included within the notification or not. Full stop. The notification under section 3D1, 3D within bracket 1 of the 1956 Act was issued on 30/3/2022, declaring that the land specified in the schedule to the said notification would be acquired for the purpose of the project. I go to project NH project. In the said notification dated 30/3/2022. There was no reflection of the plot of land, comma, covered by dag number 415 and Pata number 81, comma, which is stated to have belonged to the petition. It was at that point of time, comma, the petitioner apprehending that this 6993 was included,
No, nothing. Everything has been excluded, Lordship.
apprehending that his plot of land covered by DAG number 415 and patta number 81, comma, was converted to plots of land covered by DAG number 693, 694, 695, and 696. The petitioner approached this court by preferring a writ petition, comma, WBC number 4191/2020. Full stop. The said writ petition, after hearing the parties, comma, was disposed of by an order dated 24/6/2022, and the motion states with a direction by granting liberty to the petitioner to submit a detailed representation before the respond number 3 hearing, that is a joint secretary, comma, revenue, comma, Karbi Anglong Autonomous Council. Dash CUM, dash the competent authority land acquisition. Full stop. It was further observed that if such a representation was submitted by the petitioner before the respond number 3, comma, the same should be disposed of by a speaking order after carrying out proper spot verification and upon due consultation of the relevant revenue records. Full stop. The petitioner stated that he had accordingly submitted a representation before the authority, comma, indicated herein above, comma, on 36/2022. And the said representation came to be disposed of by a speaking order dated 21/6/2023. By the Joint Secretary, comma, Department of Revenue, AAC, and competent authority land acquisition. From the contents of the speaking order dated 21/6/2023, comma, it is noticed that on submission of the representation by the petitioner, comma, a case, comma, LACC, page 80, stroke, bracket, PAR-LAH, bracket code. Case number 12/2022 was registered. And notices were issued to the stakeholders, to the petitioner and the assistant settlement officer, this Deepu Revenue Cycle. It further transpires that the assistant settlement officer submitted a report during the course of the said proceeding. The Joint Secretary, Revenue KAC. After perusal of the revenue records, comma, had observed that a plot of land measuring 20 biga covered by DAG number 4 and 5 situated village Mohendi Jua NC was mutated in the name of the petitioner on 18/7/2011 in pursuance to an allotment order dated 15/6/2011. Full stop. In respect of the plots of land, comma, covered by DAG number 693, 694, 695, and 696. The said authority had observed that those plots of land are located at village Mohendi Jua, block number 4. Full stop. Such observation was made on the basis of a joint verification report submitted by the officials of the Revenue Department and the Forest Department of the KAAC before him on 22/6/2023. It has been recorded in the speaking order dated 2/6/2000, 21/6/2023. Within bracket A, that DAG number 693, 694 plots of land covered by DAG number 695 and 696 of village Mohendi Jua, block number 4, fall within Jamuna District Council Reserve Forest within bracket DCRF. And as per the revenue records, comma, those DAG numbers are recorded as forest land, semicolon, and the plot of land covered by DAG number 415 of village Mohendi Jua, NC, is not included in the land acquisition plan prepared jointly by the NHIDCL, comma, the Revenue Department, comma, KAC, and the DPR consultant of the NHIDCL. From the speaking order, comma, it is further reflected that as on date, neither the plots of land covered by DAG number so and so 44693 so and so situated at village Mohendi Jua, block number 4, nor a DAG number or nor the plot of land covered by DAG number 415 of village Mohendi Jua, NC, is within the purview is under any land acquisition process for the NH project. From the above discussion, only issue that which has emerged which requires determination on the basis of a fact finding inquiry is that whether plots of land dark number covered by dark number 693, 694, 695 and 696 situated Mohendu Jua block number 4 and the plot of land covered by dark number 415 and periodic pattern number 81 situated Mohendu Jua village Mohendu Jua NC are one or different. Full stop. In the events, they are same, full stop, not like a fact finding inquiry will a fact finding inquiry on the same issue by the Joint Secretary Revenue KAC. This court is of considered view that a fact finding inquiry on the same issue by the so and so will be considered view that the Joint Secretary Revenue KAC is in the best position to examine the said examine and decide the said issue on the basis of a fact finding inquiry based on revenue records available with the respondent KAC. Full stop. Where is your representation?
Lordship, my representation is annexure 12,
Page.
page 86 it starts.
Before?
This was to the principal secretary.
He is not
Lord.
there. Not,
He is respondent number 1 in this requisition.
he is not related.
We'll file a fresh representative, Lordship, as your Lordship directs.
So, in such view of the matter, this court deems it appropriate to dispose of this writ petition, granting liberty to the petitioner to file, to submit a detailed representation along with all the supporting documents available at his disposal before the Joint Secretary Revenue KAAC within a period of 15 days from today. And if such a representation is submitted, Commander Joint Secretary Revenue KAAC shall examine the representation and the issue as to whether the plots of land covered by dark number so and so examine the issues, one, the plots of land covered by Dag number 693 so at Mohenji to a village, Mohenji to a block 4. And the plot of land covered by Dag number 415, Patta number so at Mohenji to a NC village are one or different. And whether those two plots of land are differently located. Yes. Located differently. Located at different places. Full stop. In the course of such inquiry, the petitioner should be afforded a reasonable opportunity, all the opportunities of, should be afforded personal hearing and liberty to file all documents, all supporting documents. So the petition should also be given the liberty to look into the original revenue records in presence of KAAC.
One observation, my lord, petitioner should participate in an inquiry. In the cases we have found, finds, my lord, the petitioner are not cooperating and filing the contempt petition. If their observation is there, the petitioner should also participate in the fact-finding inquiry, my lord. If he left out, my lord, then it will be difficult again, my lord, it will go lengthy, my lord. In some other cases, not in this case.
This court further, it is further observed that the entire inquiry. So the inquiry, the fact-finding inquiry shall be completed as expeditiously as possible, preferably within a period of 45 days from the date of submission of the representation. From the date of submission of the representation, preferably 45 days. In order to facilitate expeditious consideration of such representation, the petitioner shall appear before the office of the Joint Secretary, Revenue KSC on. Let us fix a date, my lord. Then it will be dispensed. Your submission will be taken care of.
My lord.
We appear, he said the other person, there are other disputes also, they are not.
Son, that the give date, my lord, the other person.
Tell me that date at 10:30 AM
11 AM.
on
15 days, certified.
15 days, he will submit.
Oh,
Let us post a date.
15 days. And March 1, second week of.
Tell me a date.
18 March, my lord.
18 March, 18/3, 2024. This order disposes of the repetition of cost.
Also, item number 2 is also same, the patta number and dag number will be different.
Oh, tell me,
Yes,
grievance is same or what?
same, exactly same.
Exactly same.
Yes,
No,
lordship.
tell me,
The dag number will be.
same petitioner or what?
No, this is another passing Daulago, lordship. Dag number
Tell me.
447 and patta number 169 is my.
Village.
Village is Mohendejua, lordship.
Same, my lord.
Same, everything
Okay,
is.
1 minute.
But only the unknown dag numbers are 698.
1 minute.
Sorry,
I am
sorry.
not that fast.
So sorry, lordship.
20 biga, huh? Dag number 447.
Yes, Lord.
Patta number
169.
169.
Yes.
Mohendi Jua
And
NC.
and date of issuance, Pata 13/4/2021.
Patta 13/4/2021. Page
Page
33.
33.
This is Patta. Allotment. Allotment আছিল নহয় এটা? 2/3/2013. Page 31 of it. Serial number. Passing.
Yes, Lord. Initially, the land was gifted to one Munin Hasnu. And allotted, he gifted the land that I have annexed.
এইটো এলটমেণ্টটো কাটি দিব এলটমেণ্টটো আগৰটো যিটো এলটমেণ্ট আছে ইয়াতে নালাগে আৰু পিৰিয়ডিক পাত্ৰ লিখি দিব Huh?
18/1/2020, this land was gifted to me by Munin Hasnu.
We are not into that.
Okay, Lord.
You only whether this plot of land is same or different.
Yes, the same thing is written.
Any read petition?
Yes, Lordship, 4192. Order dated same 24/6/2022. Same
Any
order, Lord.
petition number two. Baki notification, certification same, huh?
The unknown DAG numbers will
Unknown DAG number 693 to 696 আছিল এটা সেইটো replace হ'ব
be 698 and 699.
DAG number 698 আৰু 699 আৰু আগৰ repetition WPC number
4192, Lordship, will find
4192 2022
65 page.
Page 65 order dated same
24/6/2022.
manner of disposal same petitioner representation 36/2022 case number is on the basis of representation LACC stroke bracket PAR-LAH bracket close case number 11/2022 তাতে tag number 415 আছিল ন এই যে অৰ্ডাৰটো 20 bigas was earlier recorded in the name of one Munin Hasnu. Subsequently, Munin Hasnu on 4/5/2013 and subsequently, the plot of land stood mutated in the revenue records in the name of the petitioner and one Sri Torun Rongpi, along with Sri Munin Hasnu, on 6/4/2021. Baki Zomuna DCRF same. Forest land same. 447 or into Jua, not reflecting the acquisition plan. So only difference it. Tag number 698 and 699 whether and tag number 447 are one and same.
Item number 3.
But section 11 application for appointment of arbitrator.
Section 11. Two contract,
Yes, madam.
single petition.
Yes.
We don't know
Madam?
whether for two contract.
No, they have subsequently admitted. What has happened is that we went for a repetition as well, and there they have admitted the liability.
Yes, MS Bora. You are clubbing two contract into one petition.
Yes, madam. Because both are continuous, madam, one after another. And
Are Mr.
HK Sharma.
SK Sharma. Planning council for the petition. And MS P Bora. A Bora. Plan standing council. NHM. For both the respondents. This is an application under section 11 within brackets 6 of the Arbitration and Conciliation Act, 1996, seeking appointment of an arbitrator. Full stop. The where are the two clause,
Page 51, madam.
page,
Page 51.
two contract, two clause. Page 33 and page The
51.
counsel for the petitioner has submitted that the disputes stroke differences have arisen out of two contract agreements. Two tender processes, comma. Firstly, comma. A tender bearing memo number, paragraph 2 does. Dated 11/11/2014. And Roman 2. Tender bearing memo number so and so dated 10/6/2015. Full stop. Clause
27.
page.
Page 33 and 51.
Clause 27 of the first tender and clause 27 of the second tender provided for arbitration clauses. Full stop. Issue notice returnable in 4 weeks as MS Bora, Standing Counsel NHM, has appeared and accepted notice on behalf of both the respondents. No formal notice. Extra copies within 3 working.
Much.
May it please your lordship. This is a contempt case, lordship. Kindly see page number 9, annexure 1. This is a order, lordship.
Order.
Yes, lordship. And relevant portion is lordship in page number 12.
Hard MS
And the
and the Learned Counsel for the petition. The contempt petition, the instant contempt petition under section 12 of the Contempt of Courts Act 1971 made with Article 215 of the Constitution here is preferred alleging willful and willful disobedience of the direction of this court made in an order dated 12/5/2023, passed in a writ petition
1162 of
1162/2022. Post of the petition has averred that the order dated 12/5/2023 was duly brought to the notice of the respondents. Post of issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents
1, 2, and 3.
by raise the proceeding within 3 working days from.
Obligation.
Item 5.
Merci, your lordship. Lordship, I need 2 days further time, your lordship. Let the
Why?
matter be. Lordship was directed to take directed the Water Resource Department to take instruction regarding the representation submitted by the petitioner.
If not dispose of.
Your lordship. Your lordship dispose, but I have.
All right, your lordship may be taken up Friday, your lordship.
Okay, Friday. On the prayer of Hard Mr. P. Mohanto, Learned Counsel for the petitioner and MS Ardeka, Learned Standing Counsel representing
Water.
Mr. RM Das, Learned Standing Counsel, Water Resource Department for the respondent number 1, 3, and 4. And Mr. H. Sharma and additional senior government advocate Assam for the number 2 and 5. MS Das has sought listing of the case Monday
Yes. Monday.
in order to for the purpose of obtaining instruction in deference to the order dated 29/1/2024. The prior log is the case 29, no, sorry, where is the case? Monday.
Monday,
Monday.
All right.
Item 6.
Yes, Mr. Sharma.
Yeah, please, your lordship. My counsel, senior counsel is on legs. So can you please pass over for the
Yes, Mr. Sharma.
Lordship, the circle officer, he is also acting as the assistant settlement officer.
It is so.
So circle officer has got that power under a notification of 2017 issued by the government of Assam, Lordship.
But
But
why?
wrongly, that circle officer part is not. So
Yes.
I think,
He should proceed afresh.
Lordship, by that way, this writ petition
I
may
thought
be.
mention also the provisions.
Lordship.
Once
Lordship.
be aware that, yes, I got the notice under 18,
Lordship.
2 or 18(3). So what
Let
do you-
let him issue fresh notices as a circle officer, Lordship.
Lordship, it's covered by your Lordship's earlier order.
Right, but now Mr. Sharma, that was disposed of at the motion stage. Now Mr. Sharma has come out with the instruction that this assistant settlement officer is also the cycle officer.
Oh.
Hey, but still he has not issued the notice in the capacity of cycle officer.
Yes,
So
Lord.
Mr. Sharma is proposing that this may be set aside, but opportunity should be
Yes.
available to the competent authority to issue proper notice.
Lordship.
I think it's the deputy commissioner who,
No, no,
No, now that has been amended. This book does not contain.
sorry.
So deputy commissioner includes additional deputy commissioner. Now with an amendment
It's a
includes
circle
cycle officer.
Lordship.
Only that modification will be there now.
What is the order to? Any that can you tell the WBC number?
Lordship, 105.
10?
Up to 24.
Sahida.
Heard Mr. B.D. Bond, senior counsel, assisted by P. Shoren, Line counsel for the petitioners. Any revenue? Mr. J. Henry, standing counsel revenue department for the respond number 1 and 4, and Mr. H. Sharma, Line additional senior government advocate Assam for the respond number 2 and 5.
Notification from আমি লগত ৰাখা
The petitioners, comma, YB number, comma, have approached this court stating that they have a common cause of action. It is the case of the petitioners that they have been served. It is the case of the petitioners that they are in occupation of plots of government land. But they are in occupation of lands.
For last 60 years, man.
Government land or what?
It has been stated to be government land.
Government landlord.
Occupation of government land. Any dark number details? No.
We have given the other receipts.
Any indication there?
Yes. At page 16 to 29.
since about last 60 years. Actually, after constructing dwelling houses, etc. Full stop. The petitioners have stated that they have been paying TV,
Lordship,
Toji Bahira,
Toji Bahir,
revenue.
on the top right hand side, page 17.
In respect of the plots of land, they are occupying individually. The plots of land are situated at village Asilabil, revenue circle, Balijana revenue circle, district Valpara. The petitioners have
It's a Zolato class of land, right? That is the Lordship. Very
have approached this court on receipt of an eviction notice dated 28/12/2023, issued under the hand of the respondent number 3, that is, the assistant settlement officer, Balijana Revenue Circle, District Valpara. Where the said eviction notice is assailed on a number of grounds, firstly, there is no mention in the impugned eviction notice about the statutory provisions under which the respondent number 3 has exercised the right to issue eviction notice, semicolon. Secondly, there is no mention in the eviction notice about the land details stroke particulars from which the petitioners have been sought to be evicted. And thirdly, under the settlement rules framed under the Assam Land and Revenue Regulation 1886, more particularly, it is the authority who comes within the definition provided in section 3M of the Assam Land and Revenue Regulation 1886 who can issue such an eviction notice, and an assistant settlement officer does not come. We need a definition provided by section 3M. আগৰ আৰু চাই লওঁ। Both Mr. Hendik and Mr. Samal, State Council, have really submitted that the impugned eviction notice primacy appears to have suffered from above deficiencies. In such view of the matter, necessary steps should be necessary to recall the eviction notice. They have also submitted that the assistant settlement officer, Balijana Revenue Circle, is also the circle officer. Balijana Revenue Circle, but the impugned eviction notice has been issued in the capacity of the assistant settlement officer, Balijana Revenue Circle only.
May I pray, Lordship, that inadvertently or not inadvertently? It's up to your Lordship.
He does not know.
Lordship, that is. No,
So it is lack of knowledge,
Lordship,
not inadvertently.
Echo.
Lack of knowledge.
His version was that, Lordship.
I have not uttered a single word to what Mr. Sharma has uttered.
So they have submitted that if the petitioners are in occupation of government lands, An exercise for eviction for of the petitioners from such government lands will be undertaken as per the prescribed procedure by issuance of a notice appraised from if so advised. Full stop. Para. On perusal of the eviction notice dated 8/12/2023. Issued by the respondent number 3, this could find sports in respect of the 3 points raised in respect of the said eviction notice. The deficiencies in respect of the eviction notice on the said 3 counts have also been fairly admitted by the learned State Council, as both Mr. Hendik and Sharma as the council have submitted that the impugn eviction notice has suffered from deficiency at least on the 3 counts as indicated above. Para. 5 লিখি দিব, let to here 5 লিখি দিব, 28/12/2023. All are same date, 28/12/2023. Petitioners করে দিব। First exercise as per settlement rules only. Dispose of.
Yes, sir. Obliged.
Item number 7.
Yeah, please, Lordship. Lordship, my right to carry on business has been infringed in a manner contrary to Order 26 Rule 18 CPC.
Commercial court. So what are the powers of the commercial court?
Lordship,
Let us have the
commercial courts. Lordship will first peruse Section 8.
we'll look into that as an let us have a bird's eye view.
Lordship. Lordship, the definitions part Section 2.
What kind of power it possesses?
Your Lordship, look at Section 2. The commercial dispute 2C. 22 disputes have been listed under 2C.
No,
And-
as a court,
Yes, madam.
what kind of power it possesses?
Well, these are the subject matters. These 22 subject matters have been allotted to the commercial courts, specifically under Section 2C. And this subject matter falls under 17, intellectual property rights relating to registered and unregistered trademarks.
Lordship, that would be beyond dispute that intellectual property rights, trademarks, patents, copyright, those will be covered as commercial dispute. Now, as regards the powers which your Lordship has addressed a specific query to us, Lordship, along with this Commercial Courts Act, the CPC was amended. And various amendments were carried on to define the powers which can be exercised by the commercial courts.
Then your Lordship may look into Section 6.
Now, my basic question is,
Lordship,
the impugn orders
Lordship,
are passed by
Yes.
a civil court.
commercial court, Lordship,
Civil court which has been designated as a
Lordship,
commercial court.
Lordship.
Pure and simple.
Lordship.
So, any order
Lordship.
passed by a civil court does not infringe any fundamental right of the parties.
No,
Firstly,
Lordship,
I am saying about settle law.
Lordship, should not.
It does not. It is laid down. Your submission will not do.
Lordship,
Any interlocutory order or any final order passed by a judicial order, passed by a judicial court,
Lordship,
is not amenable under
226,
226.
Lordship,
Pure and simple.
Lordship,
Radheshyam.
Lordship, three judge bench. Overruling Surya Dev Rai.
Interlocutory, because I'm not saying judicial act. Judicial order by judicial court, I'm saying that.
Lordship.
Now, this is under CPC.
Lordship.
Some things have been amended, but it is a court which has been designated as a. And secondly, it is a pre-existing. CPC will be followed plus some exceptions carved out.
Lordship.
So how do you say that this is 226 will be maintainable?
I say 226 will be maintainable, Lordship, because it is not only a judicial order that I come against. The judicial order has culminated into judicial act, which is resulting in infringement of my right to carry on business.
No order can be, that action is different than if,
Lordship will peruse page number 138 of my writ petition, Lordship.
here the state of Assam is not a party, not required to be made a party.
Lordship,
How the state of Assam has come? Tell me,
Lordship, the judicial department.
why? How?
Lordship, when I initially filed this writ petition, I had included the Guwahati High Court represented by Registrar General as well as the Civil Judge Nolbari. But there is a Judges Protection Act, so I had to.
Judges Protection Act, when a court has passed a judicial order,
Lordship.
not tribunal or any authority, like say Commissioner of Appeal, adjudicating authority, Assistant Commissioner passing assessment order. Those are on different footing. A court of law is a different foot. A court of law is not to be made a party in any writ
I
petition.
agreed with that. I have
Right?
treated them as parties, Lordship.
So, how this state of Assam has come?
So, Lordship,
And tell me how you will overcome Radheshyam.
Lordship Radheshyam, because that judicial order has resulted into a judicial act and my right to carry on business has been affected. That is my only submission as regard that, Lordship.
Radheshyam, 9 judges bench, Miraj Kar.
It was discussed. Lordship.
There is no question of violation of fundamental right under Article 19
No,
by a judicial order. Have you gone through entire thing?
I have gone through it.
Tell me which is the exception can be carved out? Because it is may be amenable under 227.
In that case, Lordship, without going into that dispute, I would request your Lordship to allow me to strike off respondent number 1 and my petition may be considered as under 227.
I don't have the roster also there for that.
Only that much. Then the roster will be sent to the necessary bench, Lordship. Only that much.
This has to be, Mr. Saraf, this name number 1 is to be struck off by, we cannot struck off nowadays. We have to amend everything.
No, in the presence of the Registrar General.
No,
I
that
will
is
do
not
the-
permitted nowadays. There is a notification. See, it can be 227. The issue can be examined, but
No,
because I have said because of Nandini Shah, by no way you can club 226 and 227.
Lordship.
And it by no stretch it can be an application under 226.
That is not yet fully decided, Lordship.
No, decided. 3 judges bench, mister.
It has been decided that.
3
Supreme
judges
Court
bench have
orders-
decided you
Supreme
cannot
Court orders
club.
is not amenable to-
226 is completely different by
In
Radheshyam.
that case, there was no judicial act of commission, Lordship.
Which one?
The 3 judges bench which says civil court's order will not be amenable to 226 jurisdiction. In this case, it has resulted in an act which is infringing the right to carry. So there is some difference, Lordship.
Then you made all those advocate commissioner party. If they have infringed your right,
No, Lordship.
police.
As soon as they are appointed as advocate
Siliguri.
commissioners, they are acting on behalf of the
No,
court.
we don't think, Mr. Bhai, no, from any angle this is maintainable.
So Lordship, then
It
may
is up
be-
to you.
Lordship, my prayer
It
will
is
be
up to you.
consider it to as 227, Lordship.
We do not want to do this.
I pray
It is
for
up to you.
striking.
This, I'll say simply, this is not maintainable.
Lordship, liberty may be given to approach.
It is up to you.
I withdraw it.
Proper petition you file. But we will not go on converting all this. Why should we take the trouble? if the council is not taking proper steps to
Lordship,
file proper.
It cannot be said that my actions are improper. Lordship will bear you section 8 of Commercial Codes Act. It bars civil revision petition, Lordship. But 227.
227, I think L. Chandra Kumar, you go through L. Chandra Kumar.
It is unfettered, Lordship, but some kind of confusion is being created by these acts.
You try
Section
this
two.
one, but 226 is no way.
It is unfettered. 227 is unfettered, Lordship.
227,
Yes.
it may exercise jurisdiction over supervised jurisdiction, but so far 226, I found that by no way there is any window.
I am being able to correlate, Lordship. I am being able to correlate.
Neither interim order, Radheshyam says, of a court of law, nor final order is amenable under 226.
But those judgments were passed, Lordship, because there were only orders. There was no action, Lordship. Some difference is there, Lordship.
But see, otherwise also, the judicial orders neither in excess of jurisdiction
It is in excess. It is in excess.
or it has exercised any jurisdiction which is not vested in it.
Lordship, as regards commissioning, what is the law? It says that a commissioner may be appointed at my back, at the back of the opposite party. But a
That
commissioner may not.
227.
Exactly, Lordship. Exactly.
227.
Exactly, Lordship. I mean,
Mr.
withdraw with liberty to file a fresh, Lordship.
Mr. D. Saraf, learned counsel for the petitioner, and Mr. V.D. Kaur, learned senior counsel. Assisted by Mr. P. Gupta, learned counsel for the respond number 2. So also had Mr. H. Sharma, learned additional senior government advocate, Assam for the respond number 1. Full stop. Mr. Saraf, learned counsel for the petitioner, submitted that the petitioner wants to withdraw the petition with the liberty to file appropriate petition.
Appropriate application before the appropriate forums.
Appropriate application before the appropriate forum. In view of the above submission made by Mr. Saraf, the writ petition under Article 226 is dismissed on withdrawal with the liberty as paid for.
I have already told my friend that there is a judgment of the Bombay High Court in the same there because writ petition was not maintainable. Ultimately, they file under Order 39 Rule 4 because this is an ex parte order.
Friday, Saturday, I think. I think Saturday.
No, Lordship has fixed it in the month of March.
No.
Saturday it was fixed, but the additional senior government advocate, Lordship,
No, additional advocate general.
additional advocate general, he prayed for some accommodation. I can give the date, but the file is with me in my chamber. Tomorrow, Lordship, I can give the date, Lordship.
Because I am quite convinced
Lordship,
after going through
Nandini sir,
Radheshyam and all,
Lordship.
that this is to be registered as CRP. This is a civil liability.
Well, in one case, my lord, I can refer to one case, my lord.
I have decided, but
Yes.
now court can err. To err is human.
My
And that was a long pending case, so I decided.
lord. Because there was a submission made by both.
Lordship
the
will
sides.
fix this matter along with that one, but Lordship, tomorrow.
Then I have decided,
My lord,
because it was pending for a long time, 7-8 years, so instead of relegating
my lord. The matter.
to the CRP court,
My lord.
we find that no, nothing was there.
My lord.
It did not lead any evidence, but
Then-
here you have laid evidence,
The
perhaps.
My lord,
And your case was dismissed.
with the liberty to, my lord, file a fresh under 227.
It can be allowed. If you make the prayer, then because Land Grabbing Act, it says that it is deemed to be civil court.
My lord.
If it is civil court,
My lord, Unfortunately or fortunately, my lord, I made the application under 227, read with 226.
Both cannot be clubbed together nowadays.
Yes.
Nowadays, it cannot be
Yes,
clubbed
yes.
together.
Not possible.
That is a difficulty now.
My lord. In view of Nandini, my lord.
In view of Nandini as well as Radheshyam.
So rightly pointed out, my lord, some liberty be given, my lord.
Sure, sure. Mr. A.K. Podastam, learned counsel for the petitioner, and Mr. H. Sharma, learned additional senior government advocate. For response number 1.
1, 2.
1 and 2.
Lots.
Mr. Purokas has submitted that he may be allowed to withdraw the writ petition preferred under Article 226 of the Constitution of India, in order to file APRIS. Who's in view of the above submission made by Mr. Purokas and counsel for the petitioner, the writ petition is allowed to be withdrawn, with the liberated file. APRIS.
Well, I am thinking that my lord is going to dismiss my petition.
The earlier one also.
Mentally, I was prepared. Plus.
Huh?
Item number 9.
I take it.
May I, Your Worship?
Yes.
My lord, this is an application, my lord, filed by the petitioner, my lord. This petitioner, my lord, passes a plot of land, my lord, 1 kata 5 lessa, tag number 182, pata number 27, Axonia land, my lord, in the year 2022.
Axonia?
Yes, Axonia land, my lord. Since 2002, my lord. And since then, my lord, she has been possessing the land, my lord, by making a house also, my lord, Teen Sally, my lord. Now, my lord, the respondent authorities, my lord, especially the
where from we can see that this is Axonia land?
From the notice itself also it is reflected at page 31.
Yes, my lord.
Page 31.
Lordship.
In the cell deed also, my lord. In the cell deed also.
Notice, where is that notice?
Page 31.
Page 19 also.
Vernacular one. Lord.
Vernacular.
This notice was issued to the from the purchaser.
Purchaser.
They have purchased the land from this lady, Lord.
And this lady also applied for, my lord, for settlement also, my lord. That petition is pending, my lord. And similarly situated person, my lord, also filed a writ petition, my lord. Page 32, my lord. Same dag and same patta, my lord.
সরকারিকরণ করানো হবো।
Also paying the GMC tax and other revenue. Page 32, my lord. Court was pleased to protect the other petition also, petitioner, my lord, Vinu Das. Neighbor, my lord. Possessing same dag and patta land. So my humble submission, my lord, this petitioner is also only this land, my lord. He has no any other.
If it is annual patta, then Mr. Sharma.
Lordship.
I think similar order is called for.
Yes, my lord.
Till returnable date, Lordship, in the meantime, let me get this. Some more time, Lordship, let him.
And also, my lord, this matter may also be taken with another repetition, my lord.
Let us first issue notice.
Yes, my lord.
Heard Mr. T. Hussain.
Yes, my lord.
Learned counsel for the petition. MS. Mr. H. Sharma. Learned additional senior government advocate Assam for the
1, 3, 4, and 5.
3, 4, and 5. And MS and Bordoloi learned standing counsel. The Revenue Department for the respondent number 2. There is a case of the petitioner is that the petitioner came into possession of a plot of land measuring 1 kata 5 lessas covered by annual patta number 27 with tag number 182 within bracket subject block APS 33. From the R12 annual patta holder of the state plot of land on the strength of an any unregistered sale deed
11 to 2002.
unregistered sale deed
Yes.
dated 11 to 2020 2002 exactly same okay executed between the petition and the erstwhile annual patta holder full stop. Since the execution of the unregistered sale deed, the petitioner is in continuous possession of the subject plot measuring 1 katha 5 lessons. The petitioner had, in the meantime, on which date?
13/9/23.
Which date you made application?
Made application, my lord.
Application acknowledgement.
Acknowledgement.
Date
17/3/20.
17/3/2023.
Notice is also same lordship
Ah.
as reflected in your
So
lordship.
from the respondent number 5, oh sorry, or apply for settlement of a subject plot in her favor. Yeah, 33 order to same. Kali ek kota 5 past lesser. 13/9/2023 same.
Yes, lordship.
Respondent number 5.
Yes.
5. Same. By him same.
Your lordship is making it returnable by
4 weeks or you want date?
the lordship.
Okay, date. Issue notice returnable after 4 weeks.
13/3.
13/3.
In them, no coercive.
No coercive.
Item 10.
Lordship already passed order in similar matter, my lord.
Okay, oh that
That
some
was,
correction got
my lord, that
right.
appeared the order. Only my lord,
Issue notice at this stage.
yes, my lord. That order and my lord date, mutation date is different.
What is the mediation date?
Page 22, my lord.
Tell me.
Oh, yes, my 28/7/98.
20,
8/7/98.
28/7/19.
98.
How much area?
1 katha only.
1 katha.
Yes. Rest are same.
Rest the same.
Council name, planet council name.
Okay. N board. Respondents are same?
Yes, same.
Otherwise?
Same.
1 and 2.
Okay. N Bodoloi.
1 and
3 to 7 lordship.
One katha. One katha. Village Obhayapuri.
Same.
Same.
Tijargram revenue circle.
Okay. Eight order.
Returnable 4 weeks lordship.
4 weeks.
Lordship.
Lordship, I have not been served any copy in this case, Your Lordship.
I'll serve one.
I would
Okay.
like 2 copies. Thank you.
You need 2 copies. Okay.
Yeah.
2 copies to MS N Bodoloi and a requisite number of copies of 3, 4, 5, 6, 7. 5 copies to Mr. Sharma.
Item number 11.
May I please, Your Lordship. This is an application under Article 226(2), Your Lordship.
We are fixing some matter.
Lordship, I was told, Your Lordship.
Same day.
Lord.
Have you come across anything?
Lordship, so far as exactly what the query your lordship has put, your lordship, that the whether against the your lordship complaint case, your lordship, whether this honorable court can exercise.
Because all this cause of action story has come under a judicial order now.
Lords,
There is a difference between Nobin
Mazithia and
Mazitha
that
and
aspect I am thinking about.
all the high courts,
Lordship,
or all the Supreme Court decisions or this high court's decision. But this is under an umbrella of a judicial order.
lords.
And I had held in one case already.
Against that this is not
Similar
making.
thing, Bangalore, I think. Mr. Sharma was there.
No,
That was a Bangalore case, Lordship.
I have already held. And now,
MP
without other Supreme Court judgments, now I have come across Supreme Court judgments.
Lordship, by considering the recent Supreme Court judgment, Lordship has delivered it, Lordship.
No, that the Learned Council presented some cases.
Recent cases, Lordship.
But I have come across now other Supreme Court decisions
Lord,
that
Lord.
this Article 226(2). In case of investigation is one thing.
Lords. That is the Mazithia itself made clear that investigation.
So if you have come across any
Lords.
Supreme Court decision
Lords.
taking such a view that this is maintainable, then this is maintainable.
Exactly same, your lordship, I have not got, your lordship.
Otherwise, I am bound by my own order.
Lords. I will go through that order also, your lordship. This is probably by MP Chaudhary, your lordship.
Maybe. So otherwise, forum is different.
Lords.
If you see from the perspective of 227 also.
Lords. Then your lordship cannot, your lordship. That is clear. So far as
And
226.
so far as Mazithia or Kusum Ingot, whatever, all are related to
Lords.
investigation and major part of, say, substantial part of cause of action.
In my case, your lordship, what has happened, your lordship?
No, that is why I stayed in one case,
Lords.
only the execution of warrant only.
Lords.
I did not stay the
Proceeding, your lordship.
proceeding.
Lords. In
Just
my
to-
case, what has happened,
No,
your
I
lordship?
know what happens.
They have filed 2 cases here,
I
your
know,
lordship.
Mr. Bhattakur, but
Lords.
I am helpless here.
Lordship.
I am also bound by law.
Lordship, lords. That's there.
I cannot extend my jurisdiction
Lords.
in that manner.
I will try to find out, your lordship.
If you can come across
Lord.
if you have come across, then it's okay. Otherwise, we'll posting it Monday. Otherwise, passing 3-4 orders will be difficult. Monday or next Wednesday, Mr.
Lordship, I am.
Bhattakur,
Lordship, I am
say 21.
21.
By Saturday, we'll decide that those. I think those cases have been fixed on Saturday.
Lordship.
Saturday is a working day.
Lordship. Saturday, I
But-
will not be available.
No, Saturday, next Wednesday.
Lordship.
We'll decide the issue. Same thing. Cholamandalam.
Cholamandalam.
Same.
Cholamandalam. Cholamandalam, I have, your lordship.
Yes, it is a case of appears to be a tool of harassment.
Lord.
Prima facie.
Lordship. Lord.
But still, there is a forum.
Lord.
It cannot be from a forum convenience from the perspective of the complainant.
There is one judgment, your lordship, of the Delhi High Court, your lordship. Single judge, of course, your lordship, not binding on your lordship. But just for
But those,
there, your lordship, the debate of the parliamentary debate on this, your lordship, on this constitution amendment 226(2), that has been considered, your lordship.
consider whether it has been laid down as a law.
Lordship. I will try to bring
Okay.
those judgments.
Mr. S. Bhattakur, Learned Counsel for the petition.
Or on 22nd, your lordship.
23rd. If I decide that issue, then
Lordship, then, Lord.
hardly one line order.
Lord.
And Mr. H. Sharma, Learned Additional Senior Government Advocate Assam for the state responsible. Place the case again in the motion column on 23rd.
Lordship.
Item number
Obliged,
12.
Lord. May I please, your lordship? Let me take up this matter after some time, lordship.
Sometime.
Obliged.
Item 13.
Lordship, matter pertains to transportation of coal, Lordship. We have an extra credentials, Lordship, that is an extra one.
What document you have come across?
That the importer exporter code, Lordship.
You are importer exporter?
Yes, Lordship.
Yes, Mr.
I am for
Gupta?
I am for respond number 1 and
1. 2 also?
2 also, my lord.
3. Okay. Third, Mr. M.K. Bora. Learned Counsel for the petitioner, Mr. H. Gupta. Learned Central Government Council for the respondent number 1 and 2. And M.S. Sharma, can you appear for respondent number 4? Director of Geology and Mining, Assam.
They have a set of counsel.
Mr. S. Bora, any standing counsel for Director of Geology and Mining? No. Mr. M.S. Sharma, Learned Junior Government Advocate, Assam for the respondent number 4.
Post up.
The petitioner has claimed that it is a farm or
Harmless.
okay. The petitioner, a proprietor of farm, is in the business of coal in the state of Assam, Meghalaya, in the states of, and it carries out its business, coal business, in the states of Assam, Meghalaya, and Nagaland. Full stop. As part of its business, the petitioner found transport coal from the states of Assam, Meghalaya, and Nagaland to different parts of the country. For the purpose of for the purpose of dispatching coal to different parts of the country in the course of interstate trade or commerce. To the respondent and every the petition is required to obtain all the necessary permissions from the competent authorities. Full stop. There are 3. There are 4. There are 5. There are 6 as Mr. Gupta. 1 and 2 are Ms. Sharma. 4. There are 7 steps by registered post upon respond number 3. There I repeat for you.
Item number 14.
May I please? My lord, may kindly see page 38, my lord. This is the last communication.
Yes.
Page 38, my lord.
38.
Yes, this is started from page 36. Your lordship, can you see page 38? The picture will be clear, my lord. I did the work, my lord, and it was completed.
When did you execute the work, Mr.
My lord,
Pine?
in Doha College, my lord.
When did you execute the work?
2007, my lord, completed.
7.
Yes, my lord.
We are in 2024.
Yes, my lord. I
What you are
understand.
doing?
No, my lord, your lordship may kindly see the communications, my lord.
When did you enforce? Making a claim repeatedly does not extend the period of limitation.
That is true, my lord, but your lordship may kindly see the
Correspondence after correspondence will not give you any cause of action.
my lord may kindly see page 37
Let
onward.
us see.
My lord, it is they have said my lord,
You have executed the work when?
2007 completed.
7.
Yes. That
End
is
of the
admitted.
matter.
The
Which
2007.
cannot be done directly, cannot be done indirectly.
Understood, my lord. But my lord, your
Civil suit could have been filed within a period of
Yes.
3 years from the date of cause of action.
Your lordship.
When a cause of action under the Limitation Act
Understood. my lord.
pursue the matter before the authorities repeatedly, vigorously in all these matters, but we do not entertain.
My lord,
Tell me
probably
by this kind of correspondence, can the period of limitation can be extended? What is the law?
law is, my lord, within 3 years. It has to. My lord, your lordship may.
16, 17 years. Let Roha College be reached,
No, no.
enriched
This is not the Roha.
by-
College, my lord. This is in between the my lord, central government and state government, my lord.
So pursue the matter vigorously.
My lord, at least one instruction. I'm not claiming, my lord. What happened to this money, my lord? That instruction. Because as per the central government, they has released the money to the state government. State government said, my lord,
Mr. Payeng, you
only for instruction. What happened to
were
this money?
sleeping for about 16 years.
I understood, my lord.
See, Mr. Payeng, making a claim is one thing, but making enforcement of the claim is another thing. And your case is the second one, making enforcement of the claim
My lord. My lord,
by this writ petition
no,
in 2024,
we claim
when the cause of action arose in 2007.
77, my lord. So
We do not give indulgence to these kind of petitioners.
my lord, I'm not asking for any notice also, my lord. What happened to only for instruction? What happened to this money, my lord? Whether it is like still lying or not?
Who will take instruction?
The state government. my lord.
MS Sharma, we do not want to proceed beyond motion stage in this case. If you can give some relief to Mr. Payeng, that is different.
He is always at liberty to approach the them.
I'm always at liberty, my lord. That is true, my lord. Only as to know whether the money, the amount is still lying there or not, my lord. That must be. If it is there, I can show that I can approve.
Okay, MS Sharma, please take instruction. Mr.
For one.
Chaudhary, here for
One, lordship.
one. Only for a week
Yes, my lord.
or 10 days.
10 days. Because what is this?
Your ICU plug will be unplugged on the next day.
If they get some
But-
instruction, my lord, then
Mr. J. Payeng. Council for the petitioner. MS Mr. S. P. Chaudhary. Central Government Council for the respond number 1. MS S. Sharma, Senior Government Bukit Assam for the respond number 2, 3, and 2, and 3. And Mr. Finance.
what is point?
Finance appearance at least is necessary. Mr. Payeng is dependent upon finance. It is somewhere lying. Finance can rescue you. Yes. Mr. Bora, can you appear for somebody from finance? Mr. S. Bora,
Yes.
Learned Counsel, representing Mr. B. Gogoi, Standing Counsel.
Number 4. 5 is the principal.
Standing Counsel Finance Department for the respondent.
Logo is there.
The
Bigoi. Not Bigoi here.
Mr. Gogoi. Inform Mr. Gogoi what deliberation we had.
Yes, madam.
The case of the petitioner is that pursuant to a contract agreement dated 5/4/2005, the petitioner executed a contract work on behalf of the respondent authorities, and the said contract work was completed on 5/4/2007. Full stop. With a grievance that an amount of rupees 41.14 lakhs has remained outstanding till date. The petitioner has preferred the writ petition. Full stop. The learned counsel appearing for the respondents have, in addition, has submitted that the writ petition is barred by limitation. Full stop. Be that as it may, they have submitted that they would make an endeavor to obtain instruction as regards the amount which is stated to be sanctioned.
It is released to the state government as per this letter.
Which is stated to be released by the central government to the state government. Release the case on 10 days after 10 days.
Yes, I'll furnish.
Release the case on 26.
Yes.
26. 2024. Mr. Pang shall furnish extra copies of the writ petition to the Learned Council for the respondents by tomorrow.
Item 15.
May it please your lordship. The petitioner before your lordship, my lord, was a public servant, my lord. He took voluntary retirement and thereafter, after obtaining permission from the competent authorities, GMC and GMDA, he started construction, sanction plan, my lord. He started construction of his house, ground plus 2. My lord, will kindly, may I take your lordship to page 35? That is the permission been granted, my lord. 34, my lord, will kindly see. Residential, my lord. Ground plus 2. The ground floor, first floor, second floor. This is the permission been granted, my lord.
34.
Yes, page 34, yes.
Where it is mentioned, ground
Is
plus
residential, my lord will kindly see. Second column, zone, residential. And my lord, ground, first floor, second floor, my lord. At the bottom, my lord will kindly see. Ground floor, first floor, second floor.
Okay.
Yes, next page 35, my lord, again, my lord, from the competent authority, it's been allowed, my lord. Sanction planned and everything. He started construction, my lord, that foundations with regard to the whole structure of tree, that concrete of first floor, second floor, and the top floor has been done completely, my lord. And the work was proceeding, my lord. When this impugned notice at page 36, they have come with 23rd November 23rd January 2024, my lord. Will kindly see, my lord, this is on the basis, my lord, that according to them, my lord, it was observed in 19 January, so and so, we're constructing a 3-story building which is located within 100 meters from the boundary of the defense land at Shantipur military station. You were personally intimated by the watch and ward duty supervisor, so and so, to stop the construction and resume the construction only after obtaining no objection certificate. You are hereby intimated that no fresh construction is permitted to a distance of 100 meters of defense establishment as it is considered as restricted zone as per Government of India Ministry of Defense, letter number so and so, and they quoted another letter, my lord, at page 37.
Sandipur Guwahati military
Santipur.
station is there.
My lord, that main office, main office is at Bhutnath main road, my lord. There has been a plot of land, 2 plot of land, wherein the public road goes in between. And one side, this group C, group D employees stays out there and they are civilians. They are civilians. So anyway, my lord, I am abiding the law and thereafter I am constructing it. This notice has been given, my lord, wherein in the last paragraph, it has been stated that if I am doesn't obtain NOC, then FIR will be filed against him. My lord will kindly see, as per this notice at paragraph 2, 100 meters from Defense Ministry. That is this one. This law, my lord, this circular has been passed on the basis of at least 39, my lord will kindly come. Work of Defense Act 1903. This is the act I have annexed, my lord. Section 3 is the said provision under which these circulars are made. Declaration and notice of that restriction will be imposed. Now, this is the provision, my lord, and that the whole procedure has been laid down. Nothing has been followed. That such may be kept for free from building and other obstruction. A declaration shall be made to that effect under the signature of secretary to such government or some officer duly authorized to certify its order. 2, my lord, the said declaration shall be published in official gazette. Nothing, no publication, nothing, my lord. And under that one, my lord, will kindly come to, my lord, in 2011, at page 53, my lord, will kindly see. They have come out with this circular, my lord, 18 May 2011. A, B, my lord, will kindly see, where the local municipal laws do not so requires. Yet the station commander feels that any construction coming up within 100 meters
for multi-story building of more than 4 stories. The distance shall be 500 meters. Radius of defense established can be security hazard. It should refer the matter immediately to its next higher authority in the chain of its command. In the case of next higher authority is also been convinced that the station commander may convey its objection views to the local municipality or state government agencies. In case the municipal authority, state government do not take cognizance of the said objection, that the matter may be taken up at the higher authority. It need be through so and so, so and so. Now, this is been, my lord will kindly see at page 54. That particular act of 2003 has been referred to, my lord. Defense Act of 1903. My lord. Am I clear, my lord? On that very basis, this notification of 2011. Now, subsequently, it has been modified in 2016, my lord will kindly see. 21st March, page 55. 2016, my lord, paragraph A, my lord, is very important. Security restriction in respect of defense establishment installation located at 190 stations as listed in part A of annexure of this circular shall apply up to 10 meters. So from 100 meters, it is reduced to 10 meters. From the outer wall of defense establishment installation to maintain clear line of sight of effective surveillance. Any construction or repair activity within such restricted zone of 10 meters will require prior no objection certificate. Am I clear, my lord? We'll kindly now come to, my lord, that annexure 1A. That starts from, my lord, page 57. I take your lordship to, my lord, Eastern Command at serial number 43. Page 58, my lord. 43, my lord, Guwahati, Narengi, Bokhisto, Borja, Hantipur. Guwahati. So that is the thing, my lord. And that is 10 meters. I got the permission in 2021. So this was applicable, my lord, 10 meters. I got the permission, my lord, the date I am putting it before this honorable court. That is on 8/7/2021. Till that, there was no modification, it was 10. Within that time, I constructed all of the structure of ground, first and second. So far, the structure is concerned only. Now, my lord, they come with another notification now. Page 70, my lord, can you see? 23rd December 2022. Yes. Now at paragraph 2, my lord, will kindly see 2, Roman 2, my lord. I'm reading it, my lord. Where the local municipal law do not require, yet the station commander feels that any construction coming up within 50 meters radius. So from 10 meters, it is increased to 50 meters radius of defense establishment which are listed in Annexure A is a security hazard. It should refer the matter immediately to the next higher authority in the chain of its command. In case of next higher authority is also convinced, then the station commander may convey its objection views to the local municipality or state government agencies. In case of municipal authority, state government do not take cognizance of state objection, then the matter may be taken up with a higher authority if need be through so and so, so and so. Provided that, kindly see, my lord, A. For all the defense lobby not listed in Annexure A. So mine is whether listed or not. That for that purpose, my lord, will kindly, I have annexed the list. Page 72, it starts, my lord. Page 73, 26, my lord, that's serial number. It comes in. So my falls within 50 meters. By this notification. My construction is beyond 50 meters. And so coming to know about it, they send me notice 100 meters. In that view of the matter, my lord, I am praying before this honorable court with folded hands to stay this impugn order on the face of the record, my lord. It is illegal. When a structure is already built, my lord, and all been done, can you revert back again?
Notice you have been asked to demolish or what?
No, my lord, to stop the construction.
Okay, then we'll hear them in a returnable date.
Yes,
but I will keep this open, but at least they should come. Because if it is demolished, definitely I will. That is a different matter.
Otherwise also,
Stopping construction and demolishing is different.
Otherwise also, my lord,
We'll examine that issue.
My lord, may kindly come to page 37, Lordship.
37.
Page 37, Lordship. This is the letter issued by the group commander, Lordship. It starts from page 36, Lordship. Page 37, my lord, may in the first paragraph itself, Lordship, another letter also reflected, Lordship. It is 21st of March 2023, Lordship.
We didn't receive any other notice,
2000
only this we have received.
This is a land policy of the Lossi MOD Lossi. Probably that 50 was extended to that. That part
Will you examine that there shall not
Otherwise
be any
also-
coercive action.
Otherwise also Lossi make
No
coercive action.
There shall not be any coercive action.
Absolutely.
paragraph
my
3
lord.
Lossi.
My lifetime income I have put in my house.
Paragraph 3 Lossi. Paragraph 3
Which one?
Lossi, what authority has says Lossi, since the land falls under a restricted zone, you are advised to obtain NOC certificate from the local military authority of Narangi for the Commissioner of
Will
Guwahati.
examine whether you have the authority or not.
Absolutely, my lord.
Lossi. Lossi. Otherwise, it
Issuing a
is,
notice that I have the authority will not do.
I am not saying that.
You have to show from in black and white that you have the authority to issue such a notice
Lordship,
by Lieutenant General.
Lordship,
Somebody must be
Lordship.
vested if you have first thing, whether you have the authority or not.
Lordship,
Secondly, whether this kind of officer has the authority.
Lordship,
If yes, to the first question.
Lordship.
And thereafter the other factual things, 50
Lordship.
meters, 100 meters.
Other
Because
thing also, it is a-
otherwise defense
it's a defense.
act.
It is,
Yes,
as per the
we are
defense act,
conscious of that.
it is,
We are conscious of that.
as per the defense act, it's up to 2000 yards.
Now, what
Lordship.
kind of military establishment? you
2000 yard loss. Up to 2000 yards loss. MOD has loss is the strategic restrictions regarding.
Now, what
that
is,
their loss.
what is any work of defense? Tell me,
Lordship.
what is any work of defense?
Lordship, probably their security reason is there, Lordship, administrative, strategic reasons.
Come up
Lordship.
with that.
I will come up with that. Otherwise, it is not an adverse letter, Lordship. It is here the petitioner is advised to approach the authority, Lordship. A
Why
paragraph
should we?
3, Lordship.
Whether you have the authority or not, let us examine.
Lordship. Even Lordship Act also says that the notification also says that power is vested to the MOD, Lordship.
Now,
So Lordship
there
may
has-
issue
no.
for a moment short notice. I will reply.
Mr. Gogoi, we have seen only circulars,
Lordship.
not notifications.
Lordship.
Absolutely.
We have only seen circulars.
Lordship. Lordship.
Now here,
Section 3 talks about gazette notification.
Without gazette notifications, Lordship, Defense Authority cannot survive, Lordship, if the cantonment rule is there, Lordship, since 2018 year, Lordship.
it should be gazetted.
Lordship.
Absolutely. Gazette.
And plus,
One question is that is a remote question, my lord. 2016, it talks about 10 meters. I have constructed my building structure. Now 2024, they will come in 5 meters. So I have to demolish it or what? That is the
any
motivation.
work of defense, is it defined
No way.
Hmm?
It's not been defined, my lord.
in the act?
Even I went to the extent, my lord, with regard to establishment. What is establishment? That is not been defined, my lord. We find it establishment only in shop and establishment, Assam shop and establishment. That's all.
Establishment is a very generic term.
Yes,
But,
yeah.
Works of defense,
Absolutely.
Whether
my lord.
is
It's
it
not
defined?
workshop, my lord. Civilians resides there, my lord. Great good group C and D.
I heard Mr. A.K. Bhuyan, learned counsel for the petitioner.
Time for 1 to
Mr.
4.
K. Gogoi, learned central counsel for the response number
1 to 4, Lordship.
1 to 4. Mr. S. Pora, learned standing counsel GMC, GMPA for the response number 5 and 6. The petitioner has stated that after obtaining due permissions from the respondent GMC and the respondent GMD, for construction of a building, Z plus 2 in his plot of land measuring 2 kathas. The petitioner has already constructed roofs of his building, building within bracket Z plus 2. In the year 2021, that's 2022. Full stop. The petitioner is agreed by issuance of a which page?
Page, my lord, 36 is the type copy, my lord.
Issuance of a notice dated 23/1/2024 by the respondent number
My lord. Commander Station, Group Commander, yes.
respondent number 4.
Four. Group
Four.
Commander. Group Commander, yes.
Whereby the petitioner has been informed that no phase construction is permissible up to a distance of 100 meters of a the defense establishment. Full stop. Stating that the petitioner's plot of land falls within the restricted zone, the petitioner has been asked to obtain no objection certificate from the local military authority. Post of the notice has further indicated that in the absence of a no objection certificate from the local military authority, the respondent number 4 would initiate first information report as per procedure. Mr. Nial, counsel for the petitioner, by referring to the guidelines for issuance of no objection certificate, issued on 18/5/2011, 21/10/2016, and 23/12/2022. Annexer Roman 6, Annexer Roman 7, and Annexer Roman 8. Has submitted that the petitioner's plot of land is beyond 50 meters. 50 meters. And at the time of obtaining the NOCs from the municipal authorities like GMC and the GMDA, the same norms were followed, and as such, there is no authority and jurisdiction on the part of the respondent number 4 to issue the notice dated 23/1/2024, with the further observation that FIR will be instituted in the absence of any no objection certificate from the local military authority. First up, Mr. Gogoi has objected to the submission. Issue notice returnable on so 11/3. 11/3 as so and so appears, accepted, no formal notice. Having regard to the projection made by the petition on the basis of the guidelines, annexed as so and so, annex 6, 7, and 8. And no objection certificate issued by the respondent number so and so. It is observed that till the returnable date, the status quo as regards
No coercive
the
action
building
should
of
be
the petitioner and shall be maintained, and there shall not be any coercive action
Lordship.
by the respondent authorities. Respondent number 1, 2,
And
4
one, two,
authorities. On the basis of the impugned notice.
Lordship.
Deeply obliged.
Item number 16.
First, my lord.
Yes.
My lord, petitioner agreed person, my lord.
Kabir Ahmed Choudhury, yes.
My lord, respondent number 4, issue order, issue formal.
Respondent number 4,
Order.
executive engineer, okay.
Yes, my lord.
Here,
Formal work order, my lord, page 16.
PS 16.
Formal work order for implementation of package.
Package number 7.
Consist new scheme,
Hatigram
Hatigram.
pipe water.
pipe water supply scheme, Silchar
Yes.
division. my lord. My lord,
Uh-huh.
Respondent number 4, gone to this area, my lord, Bhattiagram area, and decided land for establishment of new scheme, my lord. Kabir Ahmed Chaudhary is a landowner, my lord.
Hmm.
Landowner, my lord. And orally discussion, my lord.
Is there any mention of your
Yes, my lord.
plot of land in this work order
Yes, my lord, land,
that you,
High
that this
Court
land will be utilized for
5 quota land.
construction? Where is that?
Uh,
In Annexure A?
in except A, my lord. Copy of the project report order dated 3/10/2023, my lord.
From where you are reading? From where you are reading?
My lord.
Annexure A?
That is on page 20, your lordship. It's reading from page 20.
Page 20, my lord, representation. Selected land, my lord.
So what is your case basically?
My lord, my case is a Kabir Ahmed Chaudhary landowner. Landowner means, my lord, a new scheme established, my lord. The respondent number 4 gone to this Bhattiagram area, my lord. And Bhattiagram area, my lord, and decided the Kabir Ahmed Chaudhary land and selected.
Where from we can say that? Is there any reflection
Yes, lordship.
in the
Yes,
Annexure
lordship.
A?
Kabir Chaudhary, betel nut cutting, 15 nodes betel nut cutting, and 5 quota land, art
No, in
building,
Annexure A, this DA builder has been given the work order.
my lord.
That you are awarded the work of package number 7.
Yes, my lord.
New scheme of Bhattigram pipe water supply scheme.
Yes, my
Right?
lord. My lord.
Now, this scheme is to be installed at this place. Is there any mention?
Yes, my lord.
Where is that?
No mention, my lord. This
No mention.
No mention, my lord.
Actually, they have no.
My lord,
place at all.
selected this area.
What? No mention.
Selected this area, my lord. Only discussion.
Huh?
Land selected. Land
There is no
select.
formal order. So what is
Yes.
your grievance?
Oral discussion.
Oral discussion, or you are enforcing your right in a writ petition, oral discussion.
15 betel nut cutting. 15 betel nut cutting. So page 13, 31, my lord. NOC submit before.
What is NOC submit? See, the work order has been issued. There is no reflection that this scheme is to be installed in your plot of land.
Yes.
Right? Then you are making representation.
Representation.
No, you are not the representationist. Somebody else.
My sign is no, my lord.
Huh? Your signature is there.
No, my lord.
No. What they are saying?
My lord, I'm damaged, my lord.
Kabir Ahmed Chaudhary having length and breadth 62 feet, 62 feet selected.
Yes,
Selected on what basis? Verbal.
Verbal, my lord. Verbal selected, damage, so land damage.
Go on pursuing verbally.
Yes, my lord.
What we have to do? You have no legal right
My lord.
and there is no corresponding legal obligation.
My lord.
So how can you enforce this? Get something in writing. All these betel nuts, page 30.
Yes, my lord. Page 13, 31, my lord.
We don't know.
31, 32, my lord.
File a civil suit then. Get injunction order.
My lord.
Without giving any work order.
My lord.
Right?
My lord.
They are trying to dispossess you or destroying your properties
My lord.
on patta lands.
My lord.
Get an injunction order against them and get compensation assessed.
Lordship, if I
There
may.
is no written work order.
Yes, my lord.
There is nothing in
What
black
is
and
block,
white
my
that your plot of land will be utilized for installation of pipe water scheme.
my lord.
How can we go on examining? I'm dismissing.
Liberal. Liberal withdraw.
You want to withdraw? Come up with some writing that yes, my land is being utilized for installation.
My lord.
Mr.
N.
N. Rahman.
N. Rahman, my
Now, the council for the petitioner has submitted that the petitioners want to withdraw, withdraw the writ petition, come out with the liberty to approach again with better particulars. MS
M. Kalita, your lordship.
M. Kolita Learned Council appearing for
Mr. P. N. Goswami.
P.N. Goswami Learned Standing Council Public Health Engineering Department for the respondent number 1 to 4
1 to 4.
has submitted that if the petitioner withdraws the writ petition with the liberty paid for, comma, there is no objection. In view of the above submission made by Mr. Rahman and counsel for the petitioner, the writ petition is dismissed on withdrawal, comma, with the liberty as paid for.
Deeply obliged.
Highly obliged, your lordship.
Item number 17.
Yes.
So the petitioner, he is the owner of a plot of land, my lord. Over the plot of land, a pipe of Indradhanus, my lord, gas grid limited, my lord, that is been passing through. As such, that a portion of that land has been acquired, my lord,
Okay.
and
You are not getting compensation.
my lord.
Yes, CGC.
There was an objection to the release of the amount, my lord, and that objection has been dismissed by the civil court, my lord. That order, your lordship will
Okay.
find page 22.
Indradhanus. I think for Indradhanus, in one case, Mr. Andika appeared. Find out. Heard Mr. P.K. Munir, like counsel for the petitioner. Where is Mr. K. Gogoi? Call him. Huh? Okay, Likiba K. Google and Central Government Council for the respond number 1. MSS Rama. Junior Government Advocate Assam for the respond number 2. Full stop. Agree by non-disbursal of an amount of rupees
13 lakhs.
13 lakhs 66,729 plus interest, comma, the petitioner is approached this court by the instant petition. It is a case of the petitioner that the respondent number 3, in order to exercise the right of user under the provisions of the petroleum and mineral pipeline within bracket acquisition of a right of user in land bracket close comma act comma 1962. The respondent authorities have utilized a plot of land covered by tag number 387
Yes, my lord.
and pattern number
79.
comma, at village Sunapur Pathar, comma, Sunapur Revenue Circle, District Kamrup Metro. Full stop. Issue notice returnable on
13.3.
as Mr. Gogoi, CGC for the respond number 1 and MS Sharma. Junior Government Advocate Assam appeared accepted. No formal notice. Extra copies by tomorrow. The petitioners have take steps for service of notice. On the respond number 3 and the respond number 4 by registered post to AD within 2 working days.
Obliged. Obliged.
Okay. Yes. Yes, ABT Hawk.
Item number 18.
May I please, your lordship? What, in this case, my lord, my prayer to the limited, my lord, area that, my lord, police should not act at the instance of respondent number 5. What happened, my lord, in this
Okay,
case?
then we'll examine it too.
Okay. Obliged. Lane, my lord. The respondent number 5 has filed a, my lord, civil suit before the Munsif Noagao, and thereafter civil judge Noagao. Thereafter it was shifted to my lord Shankar Devnagar Hujai. And writ petitioner also filed the, my lord, civil suit, praying for my lord, declaration of possession and permanent injunction. Both the party prays for more same prayer. My lord. During the pendency of the these two civil suits, my lord, the respondent number 5 has filed FIR before the officer in charge Suzai police station. Then they have arrested one of the, my lord, writ petitioner herein. Then he was granted bail. Now what happened, my lord? The police, we have also filed FIR repeatedly, one after another. Then after we filed a CR case, then also informed the superintendent of police Huzai about police action, my lord. Illegal police action to dispose us from our land, my lord. So here our limited prayer is that, my lord, we should not be disturbed by the police, my lord, till decision in civil suit without the order of the court, my lord.
You have filed an injunction petition.
Yes, that is not under consideration for hearing. Under
Then
consideration.
why one parallel proceeding?
Madam, I'm not paying for parallel proceeding. I'm only police action, madam. I'm only against the police action because there is no order of the court. Without having, at this stage, my lord, I pray for a notice only. And lordship may observe, my lord.
The representative you have filed 144, 145, 146 petition.
Yes, madam. That is under consideration. That is yet to be decided. And I have filed, my lord, CR case, and I have also made a complaint to the superintendent of police Hujai, my lord, at page 39.
All these issues can be taken care of by the civil court.
My lord, so far as the dispute with regards to land is concerned, my lord, that will be
If
decided.
disposition is the main aim of the police officer,
Yes, my lord.
then you can definitely get
My lord, from the
order
civil
of injunction.
my lord,
When that court is not granting you, because this is a forum.
yes, my lord.
This is a forum.
Both the parties are,
If that court has not granted you the protection,
my lord,
then
court
there
has
is a
also,
provision for appeal.
no, my lord, court has not granted any order. This is under consideration. Court has also not granted any order in favor of the private respondent number
Right.
5. At this stage, what
If
happened?
you have preferred an injunction petition seeking your protection
Yes, ma'am.
before a court,
Lordship.
that court is still considering.
Yes. Yes, ma'am.
And there is a provision for appeal also.
I'm not, my lord, about disposition. I'm only about, my lord, police inaction. Action, my lord, not inaction, action, my lord. We have made specific, my lord, readings to that effect.
In view of so many litigations between you, how this petition is to be entertained?
My lord, so far the civil, my lord, proceedings are concerned.
What you have preferred? Let us see your miscase.
My lord, page 16 is the, my lord, title suit filed by the private respondent number 5 and others, my, 2 others, my lord.
Let us see your miscase.
Page 30, my lord, annex 3.
Page
30. 30, my lord. From page 32, paragraph 6 onwards.
What order court has passed?
Not passed, my lord.
Hmm?
Notice was issued, my lord, pending for consideration, ma'am.
What allegation you have made in this petition?
Paragraph 14, my lord.
File proper petition before the trial court.
Trial court, my lord, the civil suit is there.
You are trying to abuse the process of the court.
My lord, what I am on, my lord.
Litigation, counter litigation, injunction petition versus injunction petition. Court has not granted anything.
My lord,
Para 16, you have made this a vague statement. Para 14. If you have, we want to obtain relief, get the relief there. This kind of petition is barred.
my lord, what I am on, my lord, I am not on my civil side, my lord. What I am, these are the facts, my lord. I am on, my lord, police action against us, my lord, illegally, my lord. Without backed by any law, my lord.
Para 14, absolutely nothing.
Then, my lord,
When he came, when he did that thing, there was nothing.
these are the paragraph, my lord.
Heard Mr. James Chaudhary.
My lord, from
Learned counsel for.
39 onwards, my lord.
I have seen enough. And Mr. J. Hendrik, the standing counsel revenue department for the response number 1. Mr. MS.
2, 3, and 4.
Junior government advocate of some for the response number 3 and 4. Full stop. The petitioners have approached this court by filing the instant writ petition under Article 226 of the Constitution of India. Seeking the following reliefs, 1, 2, 3, para 30. Full stop. From the pleadings made in the of the writ petition, it is noticed that the petitioners are claiming
We can have 123.
rights as an occupancy tenant in respect of a plot of land measuring 23 bighas 4 kathas 15 lasses, covered by periodic pattern number 161 and act number 107, situated at Hanular Bosti Kisam, Mauja Hujai, district Hujai, subject plot for short. On the basis of a Rayati Kotian number 30, under the provisions of the Assam, within bracket temporarily settled areas, bracket close, Tenancy Act, 1971. Full stop. Tenancy Act, 1971. For short. It is a case of the petitioners that the fathers of the petitioner were the Khotian holders. They were the Khotian holders?
Yes, yes.
Full stop. In the year 2019, comma, the respondent of 5. The petitioners have alleged that in the year 2019, comma, the respondent of 5, along with some hired persons, tried to dispose the petitioners from the position of the subject plot. Full stop. That was followed by institution of a title suit, comma, title suit number 35, stroke 2020, by the respondent of 5 as the plaintiff before the court of learned civil judge junior division, seeking declaration of right, title, and interest. Full stop. Later on, comma, the said title suit was transferred to the court of learned civil judge Hojai and has been renumbered as title suit number 94 stroke 2021. So the petitioners have stated that the said title suit, comma, title suit number 94 stroke 2021 is pending before the court of learned civil judge Hojai as on date. Full stop. The petitioners have further stated that the petitioners, along with others, comma, have also instituted a title suit, being title suit number 05/2023, before the court of learned civil judge, comma, Hojai Sankar for confirmation of position, comma, permanent injunction, and declaration of their status as occupancy tenants under the Tenancy Act 1971. And the said title suit is stated to be pending before the learned trial court for final consideration. So, it has, from the pleadings, it has further emerged that the petitioners filed an interlocutory application, comma, Miss J case number 02/2023, in title suit number 05/2023, seeking an interim injunction against the opposite parties, which included the respondent of 5, comma, to restrain them from disturbing, stroke interfering with the peaceful possession of the petitioners in respect of the subject land. Full stop. The petitioners have stated that the said interlocutory application seeking ad interim injunction is also pending for consideration. Full stop. The petitioners have further stated that the respondent of 5, as the informant, instituted a case against the petitioners before the Hojai police station by lodging an FIR, and the said FIR has been registered as Hojai police station case number 319/2023. Yes. The petitioners have alleged that based on the said FIR, comma, the person from the police personnel from Hojai police station arrested the petition number 2 and the petition number 2 was released on bail after a few days by the court of learned Chief Judicial Magistrate Hojai. Post up. The petition number 1 sought approached this court seeking the benefit of pre-arrest bail, and this court had extended the benefit of pre-arrest bail to the petitioner number 1. It is the further case of the petitioner that since FIR 87/2023. The respondent number 5. Since thereafter, the respondent number 5, with the assistance of the police personnel from Hosai police station, is trying to evict the petitioners from the subject land. Because the various representations, complaints lodged by the petitioner before the Hosai police station did not bear any effective action. The petitioners have further stated that on 26/2023, the petitioners filed a petition before the subdivisional officer civil Hosai under sections 144, 145, 146A, Code of Criminal Procedure 1973, for restraining the entry of the respondent number 5 and others to the said land. Full stop. The subdivisional magistrate officer Hosai, civil Hosai, forwarded the said petition to Hosai police station for inquiry and report. Full stop. The petitioners have alleged that on 9/1/2024, the respondent number 5 and others entered into the subject land with JCB excavator and dumper and cut and indulged into art cutting. Post of complaint lodged in that connection. A complaint lodged in that connection before the Hosai police station. Despite a complaint, there was no action by the Hosai police station. Post of in the above projected fact situation, the petitioners have approached this court by the instant writ petition seeking the aforementioned relief. Full stop. Having considered the background events, this court is of the considered view that the petitioners have having gone through the statements and averments made in this state petition, it is noticed that the petitioners have not approached the learned trial court, who is trying the title suit. Title suit number 05/2023, wherein the petitioners have also preferred an interlocutory application, means the case number 02/2023, seeking ad interim injunction for not disturbing, interfering with the peaceful position of the petitioners in respect of the subject land. Full stop. This court is of the considered unhesitant view that the petitioners should exhaust the remedy, should have brought the alleged action by any of the persons, including the police personnel from Hosai police station, as regards their attempts to dispossess the petitioners from the subject land in the before the learned trial court, who is adjudicating the title suit number
My lord, 05 oblique.
05 stroke 2023, as well as Miss J case number so and so, arising out of title suit number so and so. Full stop. A prayer when litigations are pending before the competent court of law, comma, a prayer, the reliefs sought for in this writ petition, and the relief sought for in this writ petition, which could have been examined by the learned courts, said learned courts, comma, an approach, the present approach by the writ petitioner is found to be misconceived. Accordingly, the writ petition is dismissed.
My lord, liberty may be granted. Liberty to approve.
What liberty? Already I have said
That
reading the notice, yes, we have been thought to be dispossessed. Don't open another forum.
Item number 19.
My lord, this matter relates to the abolition of arbitrator under National Highway Act. Actually, on that same date, 3 writ petitions were filed. 2 were already listed. 2 were already listed and fixed on 19th February.
19th February.
Yes, WPC number 509 of 24.
Same.
We'll simply issue notice then. All are represented.
No,
Yes.
5-6, I am.
The main
Uh,
decision is to be taken by the central government.
CGC. Any CGC? DK Medhi. Okay, heard Mr.
DK Nath.
BK Nath.
D.
DK Nath, learned counsel for the petitioner. DK Medhi, learned Central Government Council for the respondent number 1. Mr. J. Hendrick, learned Standing Council Revenue Department for the respondent number 2. MS S. Sharma, learned Junior Government Advocate Assam for the respondent number 3, 4. And MS R. Bora, learned Standing Council NHIDCL for the respondent number
5 and 6.
5 and 6. Full stop. Seeking a direction to the respondent authorities to appoint an arbitrator under section 3G5 of the National Highways Act 1956 for the purpose of disposal of the arbitration case number.
Actually, it was filed subsequently. So earlier number is not.
For the purpose of the disposal of an application preferred by the petitioner seeking enhancement, stroke reassessment of the compensation amount.
This is enhancement.
Seeking enhanced stroke reassessment of the compensation amount awarded under section 3G5, 3G1.
3G1, yes.
3G1. The instant writ petition has been prepared. Full stop. Mr. Nath, learned counsel, the learned counsel for the parties have submitted that 2 other writ petitions, comma, seeking similar reliefs, comma, that is WPC number
509/24.
509/2024 and
563.
WPC number 563/2024 are ordered to be listed on 19/2/2022. And this writ petition may also be listed on 19/2/2022. Also, issue notice to the respondents. The notice is made returnable on 19/2/2024 as MS so-and-so appeared. Extra copies by tomorrow. Place the case on so-and-so.
Item number 20.
Yes. There is no representation on behalf of the petitioner today on call. Leaves the case. In the next week. Case stands adjourned for the day.
Item 123.
Yes, what is the pair?
Lordship, we basically made pair for the consideration of the claim of the present petitioner in respect of the
Okay, you are appearing.
For the bank lordship.
Any LIC standing counsel?
there is no notice will go, Your Lordship.
Okay. What is your prayer?
Lordship, debt claim, Your Lordship. This is the account was open under the Pradhan Mantri Gramin Yojana. The person in the mean of during operation, the person died.
What is your relationship? Your wife?
My wife.
Wife? Okay.
Earlier in petition, I have approached before this honorable court because they are rejected my claim saying that the name of the death certificate was issued in the nickname of the deceased. Subsequently, during pendency of the petition,
Okay, heard Mr. L. Mohan, learned counsel for the petitioner, and Mr.
A Dhanuka lordship.
A. Dhanuka, learned counsel for the response number 1 to 4. 1 to 4?
Lordship.
The petitioner has alleged that the respondents have not processed the claim of the petitioner claim made by the petitioner in respect of his wife. The claim of the petitioner for an amount of rupees 2 lakh in respect of the death of his wife under the Pradhan Mantri Jivan Jyoti Bima Yojana. Issue notice returnable on as Mr. Dhanuka has appeared, accepted 1 to 4. No formal notice, extra copies within 2 working days. The petitioner shall take steps for service of notice upon the respondent number 5 and the respondent number 6 by a step post with AD within 2.
Pendency shall not be barred to.
Let them see.
Item number 55.
Lordship, I beg to appear virtually in item 55.
Yes.
Lordship, in this proceedings, Lordship, we have challenged a notification issued under section 168A of the CGST as well as the Assam GST Act. And by virtue of the said notification, Lordships, a show cause notice for the financial year 18-19, which would have become time barred already. The jurisdiction of the department to issue that show cause notice, Lordship. This is our primary prayer, Lordships. And the secondary prayer is regarding, Lordship, the procedure to be followed before issuance of show cause. Your Lordship's order in PepsiCo, Lordships, that scrutiny of returns, then audit, then assessment. Lordship, that is our secondary ground, Lordships. In this case, what had happened on 21st of December 2023, directly a show cause has been issued, which refers to the scrutiny of returns, but no scrutiny notice.
Which paragraph?
Lordship.
Which page? Which page is the notice?
Lordship, page 46.
46.
Lordships. Lordship, page 46 is the show cause notice, Lordships, and the relevant para of scrutiny of returns is at page 47. Page 47, Lordship, second paragraph. On scrutiny of the returns of the taxpayer for financial year 18-19, it appears that the taxpayer has availed ITC from suppliers who have filed their GST returns after 30th September. So, Lordship, the basis of the demand, basis of the impugned show cause notice is my scrutiny of return. But, Lordship, this is my secondary ground before your Lordship. I would first like to urge my primary challenge to Lordship, notification 9/23. Lordship, may kindly have section 168A, which is at page number 8.
That notification is at page?
Lordship, that notification at page 45, Lordships.
31st March.
Lordship, 31st March.
Okay.
Lordship, may I read for your lordships? Lordships, I prepared a small chart of it with which is with my learned advocate there for the easy dates, lordships.
Okay, your contention is there is no incidence of force majeure.
I bow down to your lordships. I bow down to your lordships. Lordships, 4 high courts in this regard has already in the same challenge has stayed the entire proceedings of show cause. And those judgments are on record, lordships.
So it appears to be an inclusive definition force majeure explanation.
I'll place the proceeding, lordship. Lordship, first I want to place the particular section, lordship. Once lordship has gone through, notwithstanding anything contained in this act, the government may, on recommendation of the council, by notification, extend the time limit specified in or prescribed or notified under this act in respect of the actions which cannot be completed or complied with due to force majeure. Now, lordship, may please to see the proceeding of 49 GST meeting, agenda number 7. Lordship, I have this is a extract of the minutes of the meeting. Lordship, may come to page 2, agenda item 4.7, page 2.
4 point?
First, page 2. Agenda item number 4.7. Lordship, go.
4.7.
Extension of time limit under subsection 10 of section 73 of CGST Act for the financial year 2017-18, 18-19 and 19-20. Section 73 of CGST Act 2017 provides that proper officers shall issue order demanding any tax that has not been paid or short paid or erroneously refunded, or where any input tax credit has been wrongly availed or utilized for any reason other than the reasons of fraud or any willful misstatement or suppression of fact, to evade the tax within 3 years from the due date for furnishing annual return of the financial year to which the tax not paid or thought paid or input tax credit wrongly availed or utilized relate to, or within 3 years from the date of erroneous refund. That means 3 years time was there. 2.1, the issue of extension of time limit timelines under section 7310 of CGST was earlier deliberated by the council in 47th meeting held on June 2020. Considering the difficulties faced by the taxpayers as well as the officers during the period of COVID-19 pandemic, the council recommended that one, limitation under section 73 for the financial year 17-18 for issuance of order in respect of demand linked with due date of annual return may be extended till 30th September 23 under the power available under section 168A of CGST Act. Two, time period from 1/3/2020 to 28/2/2020 may be extended and from limitation period of filing return refund claim by an application under section 54 and 55 CGST Act as well as issuance of order demand in respect of erroneous refund under section 73 by exercising power under section 168. Accordingly, the notification number so was issued to implement the above recommendation of the council. Representation have been received from some tax administrations to further extent of timeline under section 73 of CGST Act for the financial year 17-18, 18-19, 19-20 to 31/12/2024 or to extend the time under section 73 to those for section 74 of CGST Act. It has been represented that difficulties were faced by government department during COVID period due to reduced staff with strict timing and exemption to certain categories of employees from attending the office during COVID period. This led to delay in process of scrutiny and audit which could be started properly only after COVID restrictions were uplifted. It has been also been represented that though the time period for issuance of so-called notice and demand order for the financial year 17-18 has been extended by notification 13 of 2022, central tax dated 5/7/22 based on recommendation of the council in 47th meeting. However, the sum is not sufficient considering the delay in scrutiny and audit process due to COVID. And the issue was deliberated by the law committee in its meeting held on 8/2/2023. The law committee took view that it may not be desirable to extend the time limit in such a manner so that it may lead to bunching of last date for issuance of SCN or order under section 73 and section 74 for a number of financial years. Accordingly, LC did not agree with the proposal to extend time limit under section 73(10) of CGST Act to the timelines under section 74 CGST Act for any financial year. Further, LC did not agree with the proposal to extend the timeline for financial year 17-18, 18-19 and 19-20 to 31/12/2024. However, LC felt that considering the delay in scrutiny, audit and assessment process for the year 17-18, 18-19, 20 due to restrictions and difficulties faced by COVID-19 period, there may be a need to provide some additional time under section 73(10) of CGST Act for the financial year in such a manner so that there is no bunching of last date for issuance of SCN order under section 73 for these financial years as well as for the subsequent financial years. LC accordingly recommended the timeline under section 73(10) of CGST Act for financial year 17-18, 18-19 and 19-20 may be extended as below by issuance of notification under section 168A of CGST Act. Then financial year timeline, then that has been extended. Proposal was given. A draft notification under section 168 of CGST Act as per the above recommendation of the law committee is placed at Annexure A. In view of the above agenda, along with the draft notification is placed for GST Council. Page number 4 is the draft notification. Then let's say may come to page 5. Third paragraph. Agenda number 7, extension of time under section 10 of section 73 of CGST Act for the financial year 17-18, 18-19 and 19-20. Then there was a discussion and finally let's say page 6. The council agreed with the recommendation of law commission made in agenda item number 4.7 along with the proposed notification.
Yes, what is your submission?
Lordships.
Lordship, another lordship, recently, Honorable Supreme Court passed an order and given a guidelines how to deal with the subordinate relations if there is a challenge to that lord. Missile in exports, Assistant Commissioner. It's in the lordship may come to lordship paragraph 32, page 16. Married lordship. From reference to the precedents discussed above and taking an overall view of the instant matter, we proceed to distill and summarize the following legal principles that may be relevant in executing cases where the subordinate legislations are challenged on ground of being ultra vires to the parent act. A. The doctrine of ultra vires emphasizes that a rule-making body must function within the purview of the rule-making authority conferred on it by the parent act, as the body making rules or regulations has no inherent power of its own to make rules, but derives such power only from statute. It must be necessarily function within the purview of statute. Delegated legislation should not travel beyond purview of the parent acts. B. Ultra vires may arise in several ways. There may be simple excess of power over what it is conferred by the parent act. Delegated legislations may be inconsistent with the provision of the parent act. There may be non-compliance with the procedural requirement as laid down in parent act. It is the function of the court to keep all authorities within the confines of the law by supplying doctrine of ultra vires. C. If a rule is challenged as being ultra vires on the ground that it exceeds the power conferred by the parent act, the court must firstly determine and consider the source of power which is relatable to the rule. Secondly, it must determine the meaning of subordinate legislation itself. And finally, it must decide whether the subordinate legislation is consistent with and within the scope of power delegated. D. Delegated rule-making power in a statute generally follows a standardized pattern. A broad section grants authority with phrase like to carry out the provisions or to carry out the process. Another subsection specifies area of delegation, often using language like without prejudice to the generality of the foregoing powers. In determining if the impugned rule is intra-vires or ultra-vires, the scope of delegated power would have applied generality versus enumeration principle. E. The generality and versus enumeration principles lays down that where a statute confers particular power without prejudice to the generality of a general power already conferred, the particular power are only illustrative and general power and not in any way restrict the general power. In the sense, even if the impugned rule does not fall within the enumerated heads, that by itself will not to determine if the rule is ultra vires or intra vires. It must be further examined if the impugned rule can be upheld by reference to scope of the general power. F. The delegated power to legislate by making rules for carrying out the provision of the act. It is a general delegation without laying down any guideline as such. When such a power is given, it must be permissible to find out the object of the enactment and then see if the rules framed satisfy the act to having been so framed as to fall within the scope of such general power confined. However, it must be remembered that such power delegated by an enactment does not enable the authority by rules regulation to extend the scope or general operation of enactment, but is strictly ancillary. It will be authorized the provisions of subsidiary means of carrying into effect what is enacted in the statute itself and will cover what is incidental to the execution of its specific provision. In that sense, the general power cannot be so exercised so as to bring into existence substantive rights and obligations or disabilities not contemplated by the provision of the act itself. The rule-making power is not expressed in such a usual general form, but specifically enumerated. Then it shall have to be seen if the rules made are protected by the limit prescribed by the parent acts.
Now, what are the orders passed by
Lordships.
other high courts?
Lordships, kindly comes to page 81 onwards. Page 81 is the first order, Lordships, of the Honorable Division Bench of the Allahabad High Court. Lordships, may I place before your Lordships? It is, she heard Shri Rakesh Ranjanagar, learned this, and Shri this, learned counsel for the petitioner. Then Lordship, para number 2, it is submitted by the learned counsel for the petitioner that the ground of second extension of the time period prescribed for issuance of show cause notice under section 73(10) of the GST Act is not sustainable inasmuch as the COVID restrictions were uplifted long back in the year 2022 and the revenue had sufficient time to complete the scrutiny and audit process. See, this takes time. List on this. In the meantime, proceedings in pursuance of show cause may go, but no final order shall be passed. Next, Lordship, page 82 is the Honorable Gujarat High Court judgment. Again, a division bench of the Gujarat High Court, Lordships. Para number 2, Lordships. It was submitted by the learned advocate that there is no ground mentioned in the notification number 9, dated this, extending the time period for issuance of show cause under subsection 10 of section 73, while exercising the powers under the CBIC and customs under section 168 of the Act. It was submitted that after the year 2022, there was no COVID pandemic in existence, and accordingly, the provisions of 168A of this Act would not be applicable for extension. He has also invited attention of the court to explanation of 168A and submitted that none of the eventuality mentioned therein existed when the impute notification was issued by the CBIC. It was therefore submitted that such extension is not sustainable in law and is contrary to the provisions of 168A. Considering the submission, issue notice returnable on this by way of interim relief, no final order shall be passed by the authority pursuant to the show cause during the period extended by the impute notification without permission of the court till the next date of hearing. Next, Lordship, page 84, Lordships. This is a division bench of the Honorable Punjab and Haryana High Court. Lordship, same. In the second paragraph, Lordships, Mr. Goyal has thus raised an additional argument in the present case by submitting that the notices issued on 27 December for financial year 18-19 are time barred and has raised a challenge to the notification dated 31/3/23 and 28/12/23 issued under 168A of the CGST Act, whereby time limit for passing the order under 73(10) has been extended. The extension was granted by virtue of the same notification or subject matter of challenge before the Gujarat High Court at Ahmedabad by placing reliance upon the interim order dated 21st passed in Messrs. New Acid Baroa and the interim order dated 17/11 of the Allahabad High Court. It refers to both the other judgments, Lordships, which your Lordships have just seen. Lordship, in the meantime, proceedings may carry on, but no final order to be passed. Page 85, second last paragraph. Lordship, page 86 is the latest judgment passed by the Honorable Single Bench of the Madras High Court, Lordships. Page 86, Lordships. Para number 4, I am placing before your Lordships. Para number 1, Lordship, the first para. The writ petition has been filed challenging the impuged notification 13 and 9/23 dated 31st March and also the notices dated 3/11/23. Issue notice, the learned counsel appearing for the petitioner would submit that notification dated this, which was issued by the respondent, is contrary to the Goods and Service Tax Act. Further, he would submit an amount of sum of rupees this was collected by the authority. He prays for stay. Considering the submission, the court is prima facie satisfied and inclined to grant an order of interim stay. Accordingly, there should be an order of till the next day of hearing.
Yes, 4 High Courts have granted stay.
Lordship, just one point, Lordships. My learned friend refers, the challenge is, Lordship, when this notification is issued. Lordship, the Honorable Supreme Court has made it very clear that 28th of February 2022 was the last date when the Honorable Supreme Court has extended the time limits.
That re-COVID order of the Supreme Court, whereby up to 28th February, okay, limitation extended. The private persons are given time limit of 90 days, say for example. That is also applicable for state also. It is not that.
No,
Same
Lordship.
logic will apply.
No, Lordship.
How you have now, since you could not complete
No, Lordship.
the process,
Lordship has seen the minutes of the meeting.
I have
And
seen.
It is not that the this
For the time being, you are keeping this under suspension, but no final order.
Lordship, my
Impossible.
submission may be recorded, Lordship. And Lordship, further, section 16(4) and 16(2) already challenged before the Institute Court is a pending adjudication of before our High Court. Lordship.
16?
16(4) and 16(2). Because Lordship, indirectly all these things are there. And regarding extension, Lordship, I place judgment of the Honorable Supreme Court. This says that court has to see whether the order has been passed, that rule has been issued in excess of the power given to so and so.
Because
This is not the case.
Supreme Court, considering all these factors regarding existence,
No, Lordship,
continuation of COVID-19.
no, Lordship.
Wait for a minute.
No,
Let me
Not that.
allow me to say something. And consider that, yes, 28 February 2022,
Yes,
henceforth, beyond 28 February 2022, yes, all are allowed 90 days. If it is applicable for private individuals, it
obviously,
is also applicable for the state.
yes,
If it cannot be that state is on a different footing. For private citizens, COVID is over by 28 February 2022. Now, in your opinion, it continues to throughout 2023.
no, Lordship.
The council
No,
is
no.
of the view.
No, Lordship has to see whether the authority has exceeded the power which there's been provided.
That will examine, but so far 4 high courts also
No,
are
that is
there.
there, Lordship. In one high court has said.
Show
that
me that Supreme Court has vacated or that later
No,
on
that-
these orders are vacated.
Without confirming, Lordship, I
Then
cannot
we
make
can
this
take a
submission.
different view.
No, Lordship,
But
maybe.
you proceed with the proceeding, but don't finalize as per the order.
Lordship.
Heard Mr. A. Kanodia.
Yes.
Learned counsel for the petitioner. Mr. Kal, you also appear for one?
Lordship, because it is under the finance ministry, I can.
Mr. S.C. Kal, standing counsel, CGST. For all the respondents. In this writ petition instituted under Article 226 of the Constitution of India, the petitioner has inter alia assailed a notification has assailed Roman 1, notification number 09/2023, the central tax dated 31/3/2023. Annexer bracket or Victor Roman 1 and a demand cum show cause notice dated 21/12/2023. Within bracket annexer Roman 2 issued by the respondent number 2 to the petition. The notification dated 31/3/2023 is issued in exercise of powers conferred by Section 168A of the Central Goods and Services Tax Act, 2007 and
17.
the provision 2017 and other provisions, other identical provisions of the Integrated Goods and Services Tax Act 2017 and the Union Territory Goods and Services Tax Act 2017. Full stop. By exercising the said power, the time limit specified under subsection 10 of section 73 of the CGST Act for issuance of an order under subsection 9 of section 73 for recovery of tax not paid or short paid or of input tax credit wrongly availed or utilized, relating inter alia to the period that is financial year 2018-2019 has been extended up to 31/3/2024. Your main is that?
Lordships, only this.
Post up. It is on the basis of the said notification, comma. The demand cum show cause notice dated 21/12/2023 has been issued, asking the petitioner to show cause as to why an amount of rupees, a sum of rupees 62,06,927 shall not be demanded and recovered from the petitioner under section 73(1) of the CGST Act 2017 and corresponding section of SGST Act 2017 as ineligible input tax credit ITC received from the suppliers who did not file their GSTR TB returns and other amounts under section 16(4), 16(4), plus interest and penalty. Also, it is a contention of the petitioner that after the year 2022, there was no COVID pandemic in existence. Full stop. Attention is being drawn to the order dated. What was the Supreme Court order?
Lordship, it is at page 16 of my pleadings. Page 16, para number 9, Lordships. In Suomoto WPC number 3 of 20.
To the order dated 10/1/2022.
Lordships.
Passed by the Honorable Supreme Court of India in Sumoto writ petition, within bracket C number 3 of 2020. To contend that the Honorable Supreme Court of India, after taking all the factors into account, had extended the period of limitation up to 28/2/2022. Full stop. Thus, comma, there was no occasion for the council to take resort to COVID-19, the factor of COVID-19 pandemic, in order to extend the period, or in order to extend the time limit under subsection 10 of section 73 of the CGST Act. Full stop. Attention is also from Mr. Learned Counsel for the petition, has also contended that the Honorable page 81.
81 is Allahabad, Lordship, left side.
Honorable Allahabad High Court.
Lordships.
Wide annexer Roman 4 order, comma, the Honorable Gujarat High Court, wide annexer Roman 5 order, the Honorable Punjab and Haryana High Court,
Lordships.
White Annexer Roman 6 order, and Honorable
Lordship
Madras High
Madras.
Court,
Lordship Madras High Court.
White Annexer 7 order. I have granted interim protection to the notices, similarly situated like the petitioner hearing. Full stop. Para in this Mr. Kyle Leonard signing off. CGST has contended that para 32, right?
Yes, judgment, Lordship.
In Naresh Chandra Agarwal versus in civil appeal number 4672 of 2012, within bracket Naresh Chandra Agarwal versus Institute of Chartered Accountants of India and others, decided on 8/2/2024, the Honorable Supreme Court of India has dealt on matters relating to challenge made in respect of rules made in exercise of powers conferred by the statute, governing statute. Full stop. Where issue notice returnable on 15/3. 15/3. Having regard to the explanation provided to section 168A in the explanation to section 168A of the CGST Act 2017, the expression quote unquote force measure unquote has been explained, and it means a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of the Act. Full stop. It is noticed that the time limit under subsection 10 of section 73 of the CGST Act had been extended a number of times.
Lordship, this was the second extension.
Was extended once prior to the notification dated 31/3/2023.
Yes.
Full stop. Having considered the
Lordships.
entire aspect, the Honorable so and so High Court have provided interim relief to the notices by internally observing that the proceedings in pursuance of the impugned so cause notice may proceed, but no final order shall be passed. Full stop. Having considered the above aspects, including the orders passed by the Honorable so and so High Court, it is provided that till the returnable date, no final order in respect of the show cause, impugned show cause notice dated so and so shall be passed.
Grateful to your lordships.
Lordship, here petitioner is not filed their reply till date.
They are challenging the so cause notice itself.
Lordship, when Lordship, the proceeding will proceed, then without their cooperation, Lordship, without cooperation of the petitioner, Lordship has provided that in the meantime, the proceeding in pursuance of the notice will go.
Oh,
However,
okay,
no,
okay. The impugned show cause notice shall remain suspended.
Lordship,
Operation of the impugned show cause notice shall remain suspended.
but Lordship, in other high courts, I've seen that the proceeding impugned notice will may go, but no final order will be passed.
Then, Mr. Kanodia, you may
Lordships,
file your reply.
lordships, I will file my reply. I will file.
It is observed that the petitioner shall file its reply to the impugned show cause notice within a period of
Lordship, 3 weeks.
15/3. On or before 15/3/2024
Grateful to your lordships.
and
Will not pass any final order without the leave of the court.
so stop. It is further observed that the proceedings initiated pursuant to the impugned show cause notice may the process so pursuant to may proceed, but no final order
Lots,
in respect of the impugned show cause notice shall be passed.
lots.
Your lordships has listed this for lordships.
15/3.
50. Grateful to your lordships. Much older. Lordship, I apologize for appearing virtually, lordship. I will come next time. Grateful to your lordships.
Item number 56.
Yes, what is this?
My lord, on the same set of facts, my lord,
Huh?
set of figure 2 orders have been passed, my lord. One by the state, other by the center, my lord. The order passed by the center is at fine point of time, my lord. In order of the state is later end point of time, my lord.
State show cause notice was earlier.
Earlier, my lord.
You submitted reply.
I did not reply, I didn't submit reply, my lord.
And central show cause notice was later.
Later,
But they arrived at the final goalpost earlier.
yes, my lord. I am relying upon section 6, subsection 2B, 2A, my lord.
2A.
2A, my lord.
Ultimately, one proceeding will go.
You decide which one is to go. Because state was earlier, state show cause notice was earlier. Your show cause notice were subsequent. But your final order was earlier. State is yet to arrive at the final goalpost. Which one should go? Tell me, which one should go? 6-2?
Final order has been
Section
passed.
6, 2A, my lord.
Both should be state or what?
Both cannot be lordship.
Then you decide.
Yes, come
You are, tell me, center-state relation.
There is a actually,
Center-state relation, you decide.
without any lordship, because there is no coordination between the.
6-2B, it appears, Mr. Kyle,
Lordship.
it goes against you.
My lord, 2A is in my favor, 2A, my lord.
Huh?
2A also, my lord. If any authority passes the order, he also passes the order in the subsequent act, my lord. He shall intimate the other authorities also, my lord.
No, so far 6-2B say,
My lord.
where a proper officer under the State Goods and Services Tax Act has initiated any proceedings on a subject matter, no proceedings shall be initiated by the proper officer under this act, means CGST Act, on the same subject matter.
Yes, Lord.
They were, Mr. Chaudhary was earlier, so cause notice, means initiation of proceedings.
Initiation was done by us.
So you have not reached the final
Yes.
mile.
Lordship, interestingly, petitioner has not intimated the authority that early notice has been issued.
There has to be correlation also between you also.
Not sometime what's happened. Notice has been issued. It is the duty of the petitioner to point out to the authority that proceeding has been initiated. And
Right.
he was sitting over the matter and final order was passed. When second notice was issued by the state, they approached this honorable.
Tell me how to resolve. Two cannot
No, Lordship,
continue.
yes, Lordship, two connect
Now,
continue.
which one should not be continued?
That Lordship,
Tell me, you are the tax council.
since the
You know ABCD of entire this
Lordship,
act.
since,
Mr. Chaudhary,
Since the order. has
You
been
were
passed-
earlier in issuing so cause notice. They were,
Later.
they followed you. But they arrived at the final order earlier. You have not reached the final order.
They have also passed the order, my lord,
They have also.
at page 41, my lord.
Then you come up with,
Lordship, petitioner challenge the subsequent proceedings, Lordship. Page 15.
which one is, you are seeking interim relief in respect of which one?
41, my lord, the order of the state, my lord.
State.
State, my lord.
So you are agreeing to centrals.
I will prefer appeal against the center, my lord.
Okay. Then, Mr. Chaudhary,
It is clear, Lordship.
when the central has passed the order
The center has passed the order on, my lord, 14/11/23, my lord,
earlier.
earlier, my lord.
Okay. And notice was issued under subsection 73.
My lord.
Okay. Heard, Mr.
Lordship is disposing of or issuing notice.
No, issuing notice. Issuing notice. Now, this is not the first time now.
Yes, in another proceeding, Lordship.
It has started coming.
Yes, Lordship.
Now we have instructed I have instructed our authority to, before issuing notice, they will confirm from the concerned state authority.
Heard, Mr. R.S. Misrolani, counsel for the petitioner. Mr. B. Chaudhary, I am standing counsel finance and taxation for the respondent number 1, 2, 3.
2, 3.
And Mr. S.C. Cal, I am standing counsel CGST for the respondent number 4 and 5. Full stop. The SGST authorities, an authority under the SGST Act, issued a demand cum show cause notice under section 73 of the SGST Act on
23/11/22.
23/11/2022 within bracket annexure C, asking the petitioner to show cause as to why an amount of rupees
44 lakhs.
as to why the amount indicated therein shall not be demanded and recovered from the petitioner SSC for the financial year, 2017-2018. Full stop. An authority under the CGST Act had therefore after issued a demand cum show cause notice
Page 28, my lord.
on 27/4/2023.
My lord.
Also under section 73 of the CGST Act, asking the petitioner as to why the amount indicated therein shall not be demanded and recovered from the petitioner notice. I'm indicating for the financial year 2017-2018, right?
18, then 18, 19, 19, 20, my lord, 3 years.
In the other one,
Only 17, 18.
17-18.
My lord.
Then in the second case,
It is 17, 18, 18, 19, and 19, 20, my lord.
so other things may stand.
I am not seeking stay of this central order, my lord.
Okay. For the financial years 2017-2018, 2018-2019, and 2019-2020. Full stop. Both the notices had alleged that during the said period, the petitioner SSC availed and utilized input tax credit for the said amounts indicated therein under section which were inadmissible in terms of section 16(4) of the CGST Act stroke SGST Act. Pursuant to the so-called notice dated 39/2020, no, pursuant to the so-called notice dated
27/4/23, my lord.
27/4/2023, the authority under the CGST Act has passed the order in original on 14/11/2023. Annexure E. Full stop. Subsequently, the authority under the SGST Act has passed the order in original on
11/12/23, my lord.
11/12/2023. Annexure
F, my lord.
F. Full stop. Para. It is a contention of the petitioner that two parallel proceedings in respect of the same period, that is 2017-2018, is not permissible under the provisions of section 6 of the CGST Act 2017 stroke SGST Act 2017. So stop. Issue notice returnable on 15/3. 15/3. Okay, good. 17/3. Welcome to the video. 18/3. 18/3. As Venture appeared accepted, no formal notice. Full stop. Having regard to the provisions contained in section 6 of the CGST Act stroke SGST, more particularly, section 6(2)(b) thereof, now section 6(2), which inter alia indicates that once a proceeding is initiated, either of the above two acts, another proceeding for the same period under the other act is not to be initiated. Full stop. The operation of the
Page 41, my lord.
order in original dated 11/2/2023 within bracket annexure F passed by the respondent number 3 shall remain suspended till the returnable date.
Item 57.
What is here?
My lord, here, my lord, on 9/1/2024, my lord, petitioner received a recovery notice from the respondent. On 9/1/24, my lord, petitioner received a recovery notice from respondent number 3, my lord. Wherefrom he comes to know that some order has been passed. He immediately visited the office of the respondent authority to inquire about the matter. Authority apprised him that a proceeding was initiated against him, and pursuant to that proceeding, order has been passed, my lord. Accordingly, petitioner submitted a representation, my lord, seeking copy of the so-called notice as well as the order, because contention the petitioner is that
Copy of the so-called notice and
order also, because
order, okay.
it was never served upon the petitioner, my lord.
What is the mode of service, Mr. Mishra?
Speed post, my lord. Speed post.
No, I don't think so. I don't, this is CGST Act.
Finance Act
Finance Act
1994.
1994.
What is the provision? Finance Act 1994? It follows Central Excise Act, or in the Finance Act or Service Act 1994, the provision is already laid down.
Central Excise Act follows, my lord.
Central Excise Act.
Follows, my lord.
What is the mode of service?
There it is, my lord, by post, my lord.
By post. Central Excise, which one?
Lots will take after some time. I'll just point out the provision. I will point out the provision after some time, my lord.
No, it will be there. Service of notice. 37C perhaps. 37C 103. any decision or order passed or any summons or notice issued under this act, whether this is applicable or not.
Is applicable.
By tendering the decision, sending it by registered post with acknowledgement due or by speed post or by courier, approved by CB, Central Board of Excise and Customs, served in a manner by affixing a copy. Or if the decision order someone cannot be served in a manner by affixing a copy in the notice board of the officer. So this is the mode.
Madam.
37C. Write down.
Madam.
Write down what?
Yes, let's see, page 22, paragraph 1.9.
Page 22.
Thereafter, to give sufficient opportunity to the noticee, dates for personal hearing were granted on 1/9/2020.
Yes, something is on the record that registered post
I'll produce the
record is there, and he has no case.
I'll produce the record.
He has no case. If you can
Yes,
produce the registered envelope or registered details,
Yes, Lord.
registered post details,
I'll
he has
produce
no
the
case.
original record. Let's see,
Or speed post or by courier,
Hello.
then you have no case.
I'll produce the entire.
Will issue notice or what?
Lordship make for the motion hearing, I'll produce the record. Lordship may decide.
Mr. R.S. Misol and Council for the petition and Mr. SCCAL, Land Standing Council, CGST for the respondent number 1 to 4.
Yes.
Posto. It is a case of the petitioner that the copies of the
So-called notice. So-called notice as well as order mailers were not served, my lord.
copies of the so-called notice dated 4/1/2024. Annexer A.
No, my lord. It is reference, your lordship will find it page 19, my lord.
Tell me which one.
No, page 19, so-called notice.
This is order in original.
Where reference has been made, my lord.
Huh?
Reference has been given of so-called notice. It is never served, my lord, on me.
Okay. Tell me
My lord, sorry. So-called notice, C.
which
dot-
paragraph? Page
My lord, page 19, my lord.
19.
Second last paragraph, my lord. So-called notice number
Copies of the so-called notice.
dated 7/7/20.
7/7/2020. And this order also?
This order was sent on mail upon my request recently. I have not received anything. They sent it on mail.
Okay. On the basis of which the order in original dated 19/7/2021
21, my lord.
was passed, comma, was never served upon the petitioner in compliance of the provisions of section 37 C of the Central Excise Act 1944, comma, which provision is made applicable for the Finance Act 1984.
My lord.
Are you sure? I am not.
Yes, yes, yes.
By
correct.
section 83, my lord.
It is correct.
Mr. Kyle, standing as a CGST, has sought for 10 days time to obtain instruction as regards service of notice of the so-called notice, service of the so-called notice upon the petitioner in any of the modes prescribed by section 37C of the Central Excise Act.
And Lordship,
1940.
as mentioned in paragraph 1.9 of the final order, Lordship. We have given the slip number and letter number and other dates also. That notice on personal hearing was sent to the petitioner, but it.
Personnel.
Yes,
That record, that will do.
Lordship.
As sought for by the agreed to by the for the party, release the case on when?
After 10 days, Lordship. Any.
This piece 10 দিন পিছত চাই দিয়ক
26.
26
Lordship.
But so till then, some
Yes,
protection will be given, my lord.
Huh?
Some protection till then, my lord.
What protection?
Because already they have issued recovery notice, my lord.
Order is of Lordship will not, they will not proceed. I'll give it, sir. I'll instruct my client.
If they issue another notice, it will come before
My lord.
this court. File an interlocutory.
Time being item number 12.
to key. কিহৰ কাৰণে? Raghuvat Singh came on.
Made clear. Let him in the morning.
You have made Mr. Sutia wait for a long time.
Sorry.
Yes,
I here is a challenge to a notice at page 13.
notice, page
13.
13.
1-3.
1-3. Eviction notice. Jagat Singh Karan.
Firstly,
Government land.
no, it's my patta lane. I'm settlement holder. I'm next the patta at page 11. Moreover, it is the revenue officer who is not the competent authority. It's the deputy commissioner of the or the subdivisional officer.
This is Karbi Anglong, we don't know what is the law. Yes, patta land,
But
eviction notice on the ground that government land.
Notice dated 7/11/2022, my lord, has already been withdrawn, my lord.
Withdrawn,
Has
no
already
cause
been
of
withdrawn.
action.
okay, then it's fine.
I had Mr. B.P. Boral and Council Pada petitioner and Mr. J. Sutia learned standing counsel KAAC, Carving Autonomous Council, for the response number 2, 3, and 4. Also had MS, Miss Mr. Home Department. I don't know for what reason you have included. Home Department.
Assam, anyone from the government.
Okay, who is there? And Goswami Lion Junior Government Advocate Assam for the response number 1. First, the petitioner has preferred the instant petition to assail an eviction notice dated 7/11/2022, whereby the petitioner was asked to vacate a plot of land on the ground that the said petitioner is in occupation, was in occupation of the said government plot of land. Full stop. Mr. Bora's counsel for the petitioner has contended that the petitioner holds a periodic patta. In respect of the land, he is in occupation. Full stop. Mr. Sutia Lawrence, standing counsel KAAC, has submitted that the notice, eviction notice dated 7/11/2022. All eviction notices issued on 7/11/2022, including the eviction notice issued to the petitioner on 7/11/2022, have been withdrawn. Issued to all periodic patta holders
My lord.
were withdrawn.
Notice number is there, but order number.
By order bearing number so and so dated 25/11/2022. Full stop. As the eviction notice dated 7/11/2022, the subject matter of challenge in this petition, has already been withdrawn by order dated 25/11/2022, a copy of which has been placed before this court by Mr. Sutia, standing counsel so and so, there is no cause of action. No cause of action survives in this writ petition. Accordingly, the writ petition is closed.
That may be kept on record.
The order dated so and so is kept as part of the record.
Order impeachment of party item number 24.
Hard MS
A Begum. Miss A Begum.
A. Begum,
Yes, Lordship.
Lani Council for the petitioner. There is no. Yes, your implement. Who are to be implemented?
Lordship,
Madam?
respondent number 5, 6, and 7.
Okay.
It is.
The instant interlocutory application is preferred seeking implement of the following. Para 4 to 7, 1 to 3. As party response number 5, party response 6, and party response number 7. Full stop. Mr. J. Hendrick, Learned State Council, appearing for the proposed party response number 7, has submitted that. So far as implement of the party response number 7 is concerned, he has no objection. Full stop. Having regard to the statements and environments made in this petition about the necessity to include the proposed party respondents, proposed parties as, parties, aforementioned parties as party respondents in a connected writ petition, WBC number 742, silo
7487.
87, 2023. The instant interlocutory application is allowed. Full stop. The MS Begum, learned counsel for the petitioner, shall file amended cause title in terms of the notification dated so and so before the registry within a period of 7 days. The registry, after recording the causing the necessary correction, shall list the petition accordingly. Thereafter, in a motion column.
Order no steps, item number 58.
'58. '58. Yes. Any idea? MS Bordeloy? Is there any development?
Worship, this is regarding
Have been
respondent number
purchased
four,
by
regarding respondent
registered
number four.
Petitioner is saying that National Institute of Technology, Silsor authorities are disturbing him.
Yes, Your
Okay. There is no representation on behalf of the petitioner today on call. Full stop. MS N Bordeloy, learned standing counsel, Revenue Department for the respondent number 1.
one.
And Mr. J. Hendrik, learned junior government advocate Assam for the respondent number 2 are present. Full stop. As per office note dated 8/2/2024, the petitioner has not taken steps for service of notice upon the respondent number 3 and the respondent number 4 in deference to the order dated 22/12/2023. Full stop. For further 1 week's time is granted to the petitioner, for insul justice to take steps for service of notice upon the respondent number 3 and the respondent number 4. Full stop.
For exception, item numbers 25 to 27.
I'm proxy counsel appearing on behalf of Mr. B. Pusila, Lordship. Because of some medical urgency, he had to leave for Delhi, Lordship. So I'm praying for an adjournment to it.
Pusila.
Lordship.
My lord, these matters, my lord, we have listed before this honorable court by order because we have extreme urgency. My lord, matter relates to, my lord, eviction of unauthorized occupants, my lord. For the matter of construction of, my lord, overbridge at Mission Sariali, Tezpur. Now that is a, my lord, national infrastructure project. And there are some interim orders passed by this honorable court, my lord, in this writ petitions. My lord, today I cannot object, my lord.
This court
Yes, my lord.
or coordinate bench.
Coordinate bench, my lord, not by my lord. Now, my lord, pleadings are also complete. The state has,
Pusila is in Delhi.
my lord, can it be on?
Medical emergency.
No, my lord, that I
Okay,
understand.
1 week.
My lord,
He
can
will be
it be
back
on?
by end of this month, Lordship. So can it be
No,
on?
no, no, my lord, we have.
Then
access-
replace him.
Lord, can it be on Friday? We can take a chance, my lord.
Not
Because
Friday, maybe on Friday,
my
this court may rise early.
lord,
There are other tribunal issues.
we will take a chance, my lord, if lordship
Not
accommodates,
fast. No, this court will rise early.
my lord. Then, my
There
lord,
are other functions. That is also constitutional.
my lord, then can it be on 12?
Monday,
Monday 19, my lord.
Monday 19.
19, my lord.
Nothing will happen within 2 days.
No, my lord, because
Then making alternative arrangement because state is expressing urgency also. Mr. S.K. Singh will be available.
He also accompanied him, Lordship, to Delhi.
He also accompanied. Mr. A. Dhanuka, learned counsel, appearing for Mr. S.K. Singh, learned senior counsel, and Mr. B. Pusilal, learned counsel for the petitioners, have submitted that both of them have proceeded to Delhi due to certain medical emergency. Full stop. Mr. Dhanuka has thus paid for listing of the case after a week. Full stop. Mr. Borpujari, R. Borpujari, Learned Standing Council Revenue, has appearing for respondent one, has submitted that. And Mr. Vijay Talukdar, you are appearing? You are appearing for state other? Okay, Mr. N. Goswami, Learned Junior Government.
Record the name of N. Goswami.
For the respondent number so and so. 2 and 3. Have submitted that the subject matter is related to construction of what? Flyover
Flyover, my lord.
at Mission Sarili,
Test 4, my lord.
Tejpur, and has such and subject matter is a process of land acquisition
Yes.
or what?
My lord, it is
A stroke, eviction
eviction
of
of,
unauthorized occupants.
my lord.
In connection with construction of a flyover at Mission Sarili, Tejpur, and as such, comma, the matter is urgent. Full stop. As an interim order is operating against the state response. Full stop. As agreed to by the Learned Council for the party, list the cases on
19, my lord.
interim order passed earlier. Shall continue till the next date.
I'm so blessed.
Item number 28.
Yes, Mr. Rosid.
Well, in this case, the state has filed an affidavit my lord, regarding the part of the land, but that probably there is not on, I have said, there is not on record.
Epidemic opposition by whom? By whom?
There is what I have filed.
Huh?
Earlier, what I have filed. I have filed, my lord, earlier.
Epidemic opposition by respondent number 3.
Sorry, I am not a sorry.
Huh?
I am the petitioner, my lord.
You are the petitioner.
My lord.
Now, what you are submitting? Tell me.
No, on last date, my lord, there is a, my lord, order by the honorable.
Okay, additional district commissioner Borpeta shall file an additional affidavit clarifying the state aspect of the matter. Yes. Mr. Talukdar, or you are appearing?
I had filed the affidavit on behalf of the additional deputy commissioner Borpeta, Worship. So the second
When?
affidavit, this was filed on 19 of December 2022. That is the signature, Your Lordship.
Particular reason.
Instruction.
It is so filed more particularly respect to the reply has been given by the concerned. No. On
No,
10/1/2024,
on the
court has recorded after going through the earlier affidavit,
Yes. That.
something more is required.
Yes, that instruction I'm still awaiting, Your
Okay.
Lordship. Otherwise,
Mr.
Your
Rosid, then something is required, then it is required.
Yes, that I'm awaiting.
And whether you have filed the affidavit?
No, I have also not filed, my lord.
Oh, both.
Yes.
Okay, both Mr. E. Rosid, Learned Council for the petition, and MS and Bordoloi, Learned Standing Council Revenue, have sought for and are granted 2 weeks' time to file the additional affidavits in deference to the order dated 10/1/2024.
Worship, can it be 3 weeks, sir?
3 weeks. Okay. So, list the case again after 3 weeks later. Did you?
Deeply obliged. Your Lordship.
Item number 29.
Worship, in this matter, I have received recent statement.
What is the matter? I don't know.
My lord, may I be permitted to submit by my friend, my lord? My lord, matter relates to SGM oblique election of a, my lord, cooperative society, my lord.
AGM.
My lord, pursuant to a notification, my lord, we have already submitted our, my lord, nomination papers. Nomination papers, my lord, has been scrutinized. What has happened, my lord, we have elected as uncontested because against us, there was no other persons, my lord, who tendered their nomination. My lord, when the nominations were scrutinized and we have been declared as an uncontested, then suddenly, my lord, the returning officer, by responding to a high court's order, my lord, they have stayed the whole process. Now, my lord, if my lord may be pleased to peruse the order of this honorable court, my lord, is at page
28.
Let us see the notice first. Then
Yes, my lord. The notice dated, my lord, may be pleased to find at page 19 and NHO 1, my lord.
Vernacular.
My lord. The vernacular is
Papo,
at
como by homidil.
page 51.
Committee are going to 20 June.
My lord.
Election was on 20 June.
2005, my lord.
06
06, my lord. Held on. It was already held, my lord.
অক্টোবর উপস্থিত কামনা করা হল। হ্যাঁ, তারিখে। Last date of submission of nomination 10/6.
10/6.
Okay. Voter list prepared.
Yes, yes, my lord.
Okay. There is nothing or no objection.
No objection, my lord. And then, my lord.
Okay,
this-
then what happened?
Then,
On
my lord,
10/6.
my lord, may kindly turn to page 22, my lord.
Okay.
Is the person, my lord, who had been submitted there, my lord.
Nomination papers.
Nomination.
And their
papers
nomination papers were accepted.
Accepted, my lord. And
And since there is lesser than 15 numbers of
my lord,
directors,
no, my lord, out
so all their applications were accepted.
fulfill, my lord. Then, my lord, this honorable courts responding to this order at page 26. Operative parties at page.
Page 26.
Page 28, my lord, may be pleased to peruse, my lord.
Who are they?
My lord, one of the shareholders, my lord, is
Atikul Islam.
My
How
lord.
many?
only, my lord, Atikul
Three.
Islam.
Three.
Three persons, my lord.
Yes.
They have
Why they approached?
my lord, they have approached with a grievance, my lord, that since this petition was withdrawn, my lord, with a liberty.
Withdrawn.
With a
But
liberty.
still observation was made.
Yes, yes, my lord. Observation is that they
Huh.
should approach before the Registrar General. my lord.
Register.
But, my lord, they did not approach the register. And suddenly, my lord, this order at page 29, the impugn order had been passed, my lord. Now, my lord, we are challenging this page 29, my lord.
What happened thereafter?
My lord, thereafter, my lord, it has not been proceeded further. my
Okay,
lord.
this was challenged.
My lord, this is under challenge, my lord. Now, if our prayer, my lord, is that we have been, my lord, elected by following the due procedure of law. So, my lord, the quorum is also complete. We should be allowed to take over, my lord, as the board of directors and to function, my lord.
Madam, why he is shooting? Taking entire thing as per Guwahati High Court order. Where did the High Court stop? Annual general meeting. In page 28.
28th, my lord. Because the lordship, the matter filed by the other shareholder is regarding incorrect
withdrawn.
voter list. Incorrect voter list.
No, they withdrawn.
But honorable court has made
Right.
an
Election of the authority, because there is some significance.
Lordship.
Since the election of the society is fixed on 26, 2022.
My lord,
The respondent number 2,
lordship.
who is he? The registrar of
Registrar.
cooperative societies.
May
A look into the grievance of the petitioners. If the same is brought to his notice by tomorrow. The thing is, with a rider, that these petitioners have to file a representation by tomorrow, before the registrar.
Lordship.
In that event, the registrar will look into it. Court did not postpone the election process,
Lordship.
right?
My lord.
And it was the registrar only who can take appropriate action as was warranted under the law.
Lordship.
Now, what is the indication here, page 31? Oh, page 31, the original one.
Ma'am.
With reference to the subject cited above, and perhaps A is missing. As per Honorable Guwahati High Court case number dated 17/6/2022. Annual General Meeting election of Pabho so-and-so schedule on so-and-so is hereby postponed until further order. So you are directed to stop all annual general meeting process. Who is
Lordship,
he?
Lordship, who is the assistant
Who is
registrar of
he?
North Lakhimpur, Lordship.
Whether he was directed by the Registrar of Cooperative Societies.
Yes, that instruction I have, my lord.
On which date?
Lordship. Directing the.
On which date? See, did those three petitioners
My lord.
submitted any objection on 19/6?
Petitioner of the early writ petition.
Because that was the condition. That was the condition.
Lordship, we have directed the ARCS North Lakhimpur to provide a detailed report within 7 days regarding the voter list.
No. The matter was the writ petition was withdrawn,
My lord.
right? And he has
I
made
understand.
the shooting on the basis of the High Court order. High Court did not say
Didn't say anything.
that postpone,
Yes.
don't hold AGM, don't
Lordship.
hold election. And it was directed to Register of Cooperative Society.
Lordship, to take a call, my lord.
And that was with a condition
If he
precedent.
file a representation.
If those
Yes.
three file a representation by tomorrow, whether those conditions are fulfilled or not,
Lordship, sometimes.
come with an instruction, those
Lordship.
were or not.
Well, Lordship,
Otherwise,
there is
this
an
appears to be,
My lord. The
Yes,
written
appears to be.
instruction, my lord, may kindly have a look.
what, tell me, what is there?
They have
Again,
written
this
to us.
man is writing.
No,
I will not
no.
look into it.
Yes.
I will not look into it.
My lord, I will get the instruction register office, my lord.
Whether these three petitioners submitted any representation before the Register of Cooperative Societies on
My lord.
18/6/2022. That's all.
Lordship. My lord.
Otherwise, you cannot stop an election process like this. Many things are done for preparation of voters list. Heard Mr. A.R. Bhuyan,
Lordship.
Learned Counsel for the Petitioner, and MS MD Bora, Learned Standing Counsel Cooperation Department.
Lordship.
For all the respondents,
Lordship. Lordship, 3 I am not appearing. Deputy Commissioner, my signal will be.
for the respondent number
1, 2, 4, and 5.
1, 2, 4,
And 5. 6, so I can also
5.
appear because the secretary and one man committee is
one.
running.
Okay, 6. And Mr. Vijay Talwar, and it's counsel, is Mr. P.K. Medil, and counsel for the respondent number 3.
My lord.
Full stop. Having regard to the order, contents of the order dated 17/6/2022, passed in the repetition WBC numbers 4052/2022, and the order dated 18/6/2022, passed by the respondent number
ARCS Lordship.
4 minutes.
4, comma, MS Bora, Alliance Standing Counsel Corporation, shall obtain instruction whether subsequent to the order dated 17/6/2022, comma, passed in the repetition WBC number 4052/2022, comma, the writ petitioners, the 3 writ petitioners therein, or any of them had preferred any representation before the Register of Cooperative Societies
My lord.
on or before 18/6/2020.
Lordship.
That's all.
Lordship, fix a short date, Lordship.
As MS Bora has sought listing of the case on
Before 20, my lord.
20, okay. 19,
19.
to enable her to obtain the necessary instructions.
Lordship. Deeply
Place the case accordingly on suit.
My lord. Oblige, my lord.
Obliged. A2 গৈছে no list of.
Number 31.
Yes.
My lord, this matter is regarding an application under section 17A of the Prevention of Corruption Act and non-decision on that letter.
Prevention of Corruption Act 17A.
A.
Seventeen A. Inquiry. Shall conduct an inquiry. Or inquiry. Yes.
Please see page number 25 of the writ petition. That is the letter 13/1/2021 sent by 25.
Betting. Okay. Yes.
And sir, lastly, page number 146 of affidavit filed on 1st November. This is the RTI reply given by respondent number 4, Vigilance and Anti-Corruption.
146. One 46. 146.
So point number A, the competent authority in the government on perusal of the inquiry report dated 25/2023 in connection with the matter of
146 is a letter, 25/10/2023.
Yes, sir.
Okay,
Point
which
number A.
paragraph? A.
A.
Yes.
Vigilance and Anti-Corruption says that the competent authority, government on perusal of the inquiry report dated 25/2023 in connection with the matter of Dr. Durlabh Somawat deemed it fit for closure and passed order accordingly. Hence, the matter is rendered infructuous and copy of the said inquiry report could not be provided. Now, Lordship, the letter dated 13/1/2021 was decided on the basis of report dated 25/2023.
30, okay, this pays for 25.
Yes.
It is based on?
So, the letter dated 13/1/2021 was decided on the basis of report dated 25/2023. So, there is an inquiry report cannot be given along with letter dated 13/1/2021, which has an inquiry report dated 25/2023. Honorable Apex Court since 1997 again and again said that the competent authority should take the decision on the basis of documents submitted along with the proposal.
1 minute. 17A.
Yes, sir.
Which one is applicable?
Sir, actually problem is earlier
A, B
there
or
was
C?
A, 17A.
No, 17 capital A.
Yes, sir.
There are three things. Small a, small b, small c.
So that is the no police officer shall conduct.
Tell me, without prior.
Because
previous
this gentleman is retired, sir.
1 minute, 1 minute.
Sir, sir.
This says any offense alleged to have been committed by a public servant under this act, whether alleged offense is relatable to any recommendation made or decision taken by the public servant in discharge of his official functions or duties, without the previous approval. That's
Yes.
okay. He was an MLA.
He was a former MLA.
Was an MLA.
Was an MLA.
Now, whether B is applicable.
Sir, only in regards to official
Read
functional
first.
duties. It is applicable.
Please read first.
The case of person who was employed. It was applicable.
Whether he is an employee.
Was an employee. Sir,
Mr.
salary, one who has taken salary.
Oh, mister, don't generalize everything.
Yes, sir.
Don't come to generalize everything. Whether he was employed or is employed. At the time when the offense alleged to have been committed in connection with the affairs of the state of that government, or C will come. Tell me.
In the case.
Yes, Mr. Chaudhary, B or come or C will come. Whether he was under employment, I don't think so. I don't think so. Prima facie.
Prima facie, B will not come.
So every exercise appears to be redundant. To my tentative view, I think it is because it is was or is. See the clause.
Like 197.
In the case of any person, of the authority competent to remove him from his office at the time when the alleged offense was alleged to have been committed.
Yes.
If the work was done, misdeed was done, alleged misdeed, during the time of his MLA-ship, then it was the speaker. I think so.
Prima facie it looks like. But I am on a different tangent altogether. my lord.
Otherwise, all this correspondence appears to be redundant.
No, my lord, but I have,
Asking for approval from a authority who cannot give
But on merit, my lord,
Merit, we'll see.
no, on merit, my lord, this approval has been denied. When let us
No,
not go
what
to all
if
this
it is-
technically.
It is denied by an incompetent authority. It is no denial in the eye of law. Now, I think, subject to correction, there are many PCA cases against the MLAs and
Respective
Uh,
speakers are the,
who was the person who could remove. Government, I don't think secretary can refuse or approve anything. If that is so, subject to correction,
Correct.
my tentative view.
So I would make to a submission in this regard. sir.
and
You will
well,
submit.
this aspect, it was not really, I mean, it has now, once the lordship has said that,
Because I had the occasion to represent the cause of a person which
Okay.
you are doing today.
okay. No, if
Right.
if
So-
it's an MLA, it's removable by the speaker only.
From the MLSip, I think he is a public
But
servant.
there is one more aspect, my lord. If you will have to, I think we'll have to read 17A in harmoniously with section 19 also, my lord. 19 first proviso,
19 is what?
sanction for prosecution under miscellaneous provision,
No, sanction 19 sanction
sanction.
is different from 197 sanction.
Yes,
If he is not
a public servant.
at the time when the search, I don't think
Is
19
required.
comes into picture. No requirement. Only thing is 17A.
17A.
Yes.
Yes, now thing is that.
Tell me, can you throw any light
Showing
on
a government
this
circular,
aspect?
government circular.
Huh.
I am reading the government circular, PLAV 55/2003/12. That is 16.
Government circular of which?
2004. Political Vigilance Cell Department.
Government of Assam. What did it say?
Is the point E criminal proceedings? If after examination of the report of the regular inquiry, it is found by the Political Vigilance Cell Department that sufficient evidence is forthcoming for drawing up criminal proceedings against the suspected officer oblique employee, then the matter shall be.
Oh, you are
referred-
reading employee. Tell me about MLA.
Sir, that is the circular of the.
Mr. Petitioner in person,
Yes, sir.
come to the definition of public servant in the PCA 10. I think this is applicable or IPC section 21 is applicable. Say IPC.
IPC. Yet a public servant defined course.
I think section 8 earlier used to deal, I think.
Yes.
If I remember correctly, I don't know. Section 8, no. IPC 21. See, Secretary of the Government,
2C.
Home and Political Department.
Yes.
Cannot remove an MLA. It is crystal clear as water. Don't make any submission on that. The secretary can remove.
So the regular inquiry was ordered by the chief
Mr.
minister.
Mr.
The regular
Mr. Counsel, please. Counsel the petition in person. Commission officer, judge, court of justice, juryman, arbitrator, was an office of the duty and. I think perhaps 21. I think MLA is different.
A person with a license seller.
Every person who holds any office in virtue of which maybe explanation 3 perhaps.
Any person in service of or be established by or under a central provincial state act or an authority or body under.
No, explanation 3,
1 second, my lord.
the word election denotes an election for the purpose of selecting members of any legislature of whatever character. The method of selection to which is by or under any law prescribed as by election. Perhaps.
IPC এখন দিয়েছেন
If
IPC sir.
he was an MLA.
Yes.
And at the time, when he was MLA, he committed the alleged misconduct, suppose.
Yes.
Right? In that case, as per section 17A, it should be the Speaker of the Legislative Assembly,
Yes.
not a secretary, an IS officer who can remove. Because the C is very, or B or C, both are clear. In the case of any other person of the authority competent to remove him from his office, comma, at the time when the alleged offense was alleged to have been committed.
My lord will kindly come to 2CI, my lord. I think in Karunanidhi's case, it was said that, my lord, the expression is any person in the service or pay of the government. That expression was explained in Karunanidhi's case to say, my lord, a minister or a chief minister is covered by the expression person in the pay of the government. That is AIR 1979 SC 878, Karunanidhi versus Union of India. They are in the pay of the government inasmuch as they receive their salaries, remuneration, wages from the government.
It could also be 2(8) also, 2C8 also.
Yes, my lord. Any person, any office by virtue of he is authorized or required to perform any public duty. Yes.
It could be also.
Yes.
I don't know. I'm not for sure.
Lord, I got from a note from this Act only.
A contractor.
A person or a chief minister is covered by the expression person in the pay of the government.
He is in executive. Once he becomes a member of the cabinet, he becomes some kind of executive. There is
MLA
some slight distinction between MLA
Of course.
and
But when it comes to the salary, chief minister and the MLA, chief minister by virtue of being an MLA.
there must be authoritative judgment on it.
Yes.
I don't think there is no authority. Already must be.
There must be some.
I doubt there is no authority. There will be authority.
Some. It's not that an MLA as a public servant has not faced similar situation.
Yes, I think when it came to, I think one person, Sonal Sarkar,
Ah,
then
he was also an MLA.
yes, then I searched for it. Then I took the plea perhaps somewhere, like you. So,
Yes, now I remember that Chandan Sarkar's case.
so that was a case also amassing wealth disproportionate to his known source of income. He was into agriculture.
Yes, yes. I think some chairman of some board, something.
He shown as the source as agriculture.
Right, right.
So,
Sir, here the section 17A sanction is only required in case of official recommendation or functions discharging.
Mr. Petitioner in person,
Sir,
it is not a case of sanction.
this
Please
is not
under-
required actually.
Please understand. I don't know what you have understood. Sanction is under section 19,
Yes, sir.
right? And here is a case of approval under section 17A. Both are different. Mr. Come back with better research. Who was the person to remove
Sir,
an MLA from his MLA-ship?
sir, actually this,
Making submission will not do.
sir, one small line in 17A itself, it has been written that the approval is required only in case of discharging his official functions. This is the method of disproportionate assets.
Mr. Petitioner in person, I have read 3 times already. Don't try to make me understand more. Am I clear? Come with the solution. Who was the person who is competent to remove an MLA? That's all. There must be some authoritative pronouncement.
So actually, this sanction.
Maybe
is
of
not-
this court or Mr. Counsel, or Mr. Petitioner.
So
It is not a case of sanction.
yeah, this is approval. Okay, approval.
Don't equate sanction with approval. Only that one? Approval? 17A?
Every,
We are not going into the other things. Your case is only on approval. Whether secretary can deny. If the secretary is empowered to deny, then more issues will come up.
then perhaps we'll have to challenge that order.
There are other things.
Yes.
More complication will arise. If secretary is found to be competent, then other issues will arise. Right?
Sir, 3 months is the timeline. 3 years has already been passed. That is a very serious issue, sir.
No, if Mr. Petitioner,
Sir.
if you come up with the authority that speaker is the person competent to
Get decision.
grant approval, then till date, there was nothing before the speaker. Where is the question of timeline?
So the Assam Legislative Assembly has already
Oh,
given a
Mr.
letter,
Bhatt,
sir.
Mr.
So the
Vikas
government
Pujara,
order-
petitioner in person, petitioner number 2 in person, and Mr. R. Sharma, learned counsel for the petitioner number 2. 1. Mr. B.J. Taludar, learned senior counsel, assisted by Mr. P.K. Medi, learned counsel for the respondent number 1 to 4, and Mr. K. Chaudhary, learned senior counsel, assisted by Mr. B.D. Dekar, learned counsel for the respondent number 5. Full stop. Learned counsel for the petitioners. On the next date of this thing, learned counsel for the petitioners shall address on the point who is competent, who is the authority competent to remove an MLA from his office as per Section 17A of the Prevention of Corruption Act 1988. Mr. Dekar, do the research.
We'll have to do well. I think some midnight oil has to be burned now.
47, 48, perhaps a lot of things rising up. Can it be on, my lord, Saturday?
47, what are the matters?
My lord, regarding, my lord, reclassification of land.
Or whether they have come with some
I think
response.
They are supposed to come, my lord, because your lordship had direct,
I'm still awaiting my instructions. I have communicated.
You were awaiting.
Yes, your
and your lordship has indicated, in absence of instruction, your lordship will pass some interim order.
No, if the affidavit comes, we'll dispose of.
My lord, on my lord, Saturday, can it be on Saturday, 17th?
Already,
My lord,
Also, your lordship, this.
keeping everything in mind, I have already posted some matters
my lord.
for the purpose of disposal. Your
Right.
case is also there.
Yes, yeah, my case is also for disposal, my lord. So it can be on
No,
17th, my
no,
lord.
Friday it will be difficult.
No, on 17th, my lord, not Friday, Saturday,
Saturday will be difficult.
my lord,
Already I have posted 3 matters.
my lord.
47, 48. How much time MS Borduloy?
I've already communicated. Today also, I informed them.
See, Mr. Talda, you have suppose your petitions are allowed, suppose.
My lord.
Okay.
Only, my
I
lord,
think it needs expeditious disposal.
That I have.
And who are the council?
Today
RK Talukdar. Anybody, RK representing RK Talukdar?
NHN.
MS Bormon is there. SK Talukdar, petitioners. N Borlo, standing council revenue, disaster 1. And MS M Bormon, learned junior government advocate Assam for the respondent number 3, 5, and 6. Full stop. Both MS Bordoloi and MS Bormon have sought for further 10 days time to obtain instructions and to file affidavit with regard to the letter dated 2/1/2024, Annexure 8, and the order dated 8/1/2024, Annexure 9. Close the, list the cases on, list the case on. When after 10 days?
My lords, that 47, 14, madam. I have been engaged by the NSIDCL.
Okay,
My
Mr.
name-
D. Gogoi. You're writing letters. NHIDCL. For the respondent number 2.
2 months.
Okay. Gogoi, গোটেইকেইটা লিখি দিব 10 days, list the case on 26 to 2024. Same is in the other case. 48. 48.
Yes.
48, same?
47, 48, same.
They're tagged, Your Lordship. Both of them are tagged.
It is
May
coming
please, Your
together.
Lordship, in item.
Yes.
In item number.
Item number 45, my lord. Notice was issued on 8th January, my lord, returnable on today, my lord. The SGST department has not submitted any reply, my lord.
You are enjoying stay.
My lord,
We'll extend that.
yes, my lord.
Mr.
R.K. Joshi.
R.K. Joshi, Learned Counsel for the petitioner, and Mr. Finance Taxation, okay. And Mr. R. H. Borua, Learned Counsel representing Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department, for all the respondents, full stop. As no counter has been filed on behalf of the respondents, comma, this is the case after 3 weeks. This is the case on 3 weeks of issue for filing of counter affidavit by the respondents. Full stop. The interim order passed shall continue till the next set of listing. 35. Itu date di দিব. Mr. H.I. Chaudhary, Learned Counsel for the petitioner, and Mr. A.M. Borbia, Learned Counsel for the respondent number 8, have sought posting a listing of the case after 1 week. First of list the case on.
May it please, Your Lordship. Item number 51, Lordship. There is an interim order, Lordship. That may be continued. I am for petitioner.
51. Okay.
May I please, your lordship? In this case, your lordship, this matter relates to the sale of the property. And it is an DRT matter, your lordship. But it has been, that it has not been come up for listing for 2 weeks, your lordship. So kindly give us the sort.
DRT matter means division bench.
DRT matters, your lordship,
Ah.
not surfacing, DRT.
DRT is single bench.
Yes, your lord.
Have you inquired?
Yes.
It is in single bench.
Yes, your lordship.
Are you sure?
Your lordship.
Not sure.
Not sure.
Okay, list the Mr. as sought for by Ms. R. Dekar, Learned Counsel for the petitioner, Mr. M. Sharma, Learned Counsel for the respondent bank. On the prayer of so list the case on so interim order passed earlier. Shall continue till the next set of listing. Give it, we'll give it date.
May please, your lordship.
Fixed date.
Your lordships, I have a prayer with regard to item number 53, your lordships. The interim was till today, your lordships. That may kindly be continued.
Trustee, kindly please the net date, lordship. I appear on behalf of respondent number 7.
In which case?
53.
MS S. Sharma,
Yes, your lordship.
Learned Counsel for the petitioner. Any central government council? Okay, Mr. R. Boru, Learned Counsel for the respondent number 3, and Mr. MS M. Bormon, Learned Junior Government Advocate Assam for the respondent number 4, and Mr.
Respondent number 5 became on behalf, A guy on behalf.
Mr. Agayon,
On-
Learned Counsel for the respondent number 6, 5, and Mr.
7.
Name,
Alamgir. Total 7.
please name.
M. Alamgir.
M. Alamgir, Learned Counsel for the respondent number 7. Hard Korean. Hard Korean to stop.
It has already been given.
The respondent number 5 and the respondent number 7 have already entered appearance to stop as per office note. Dated, as per order dated 7/2/2024. Comma.
My lord, we are appealing for 5 and 6, my lord. A guy.
Okay, again, 5 and 6.
5 and 6.
Okay. Then, as all the respondents are represented, comma, list the repetition in the admission column after 2 weeks on a date sorry, what is the case? On a date in the week commencing from 26 to 2024, the interim order passed earlier shall continue till the next date of listing. The learned counsel for the petitioner shall furnish extra copies of the writ petition along with annexures to the learned counsel for the respondents in the meantime.
May please, your lordship. I've been repeatedly troubling your lordship over item number 50. It's an IA.
Mr. Sharma, there is some trouble.
Yes, your lordship.
One order was passed by Honorable Justice Shyam
Yes,
to list the connected writ petition before the learned single judge who had passed the order dated 11/8/2023.
Yes.
And this court is not the court who had
No.
passed the order
No.
on 11/8/2023.
Yes.
And this case is listed before this court,
Yes,
right?
yes.
That is a difficulty.
The difficulty here
Now,
also-
the order, if requires something, more punch or modification, that is to be brought before that court.
Yes.
So we'll pass some order sometime, but not today, already over.
Since your lordship, the matter,
Some interim protection, you were.
there is an interim protection as to there will be no final order till the
Oh,
next
that's
available
all.
date. But what has happened, subject to your lordship's understanding, yes, I'm not taking up much time again. The petitioner is made to defend his case on a proceeding where the maintainability is challenged before your lordship here.
Right, no
And that
final
is-
order is directed to be passed.
Yes.
That is the order today we have passed also.
Yes,
Proceeding may go on.
it may.
But
well-
ultimately,
Yes.
we find that yes, writ petition is not maintainable or
Yes.
not to be entertained.
Yes.
Then all this period will go.
It will go.
Let-
And in fact, if it's
So, Mr., you are protected enough.
yes, if your lordship can then extend and file, fix a date.
You have been, no, what is the kind of order?
11/8/2023, your lordship.
What is the kind of order?
The order is at the last
11/8.
11/8. In the IA, your lordship will find the order at page 12.
Okay, the interim order shall continue. I am Sharma for the petitioner.
Then if I may pray, your lordship, subject to your lordship's convenience to fix the date.
Mister, you are enough protected, which you have been protected
No, absolutely.
in an
absolutely. There is-
adequate manner.
Absolutely, but.
No final order will
Yes,
be passed.
Yes. No, I understand. I completely understand the magnanimity, your lordship.
If we go on passing intermediate order also,
Yes.
then other petitions will keep pending.
No, I understand that. So subject to your lordship's convenience, any day.
I am from a learned counsel for the petitioners present. The list the case after 2 weeks, the interim order passed earlier on 11/8/2023 shall continue in the meantime. Full stop. Data leave of 2 weeks.
I'm grateful, your lordship. 11.
Item number 49. I filed an IA for amendment of the pair person of the petition.
Okay, some date will be given.
Is it tender on the next week on 28th?
Next week's high level. A 49 too. Yes, Mr. Kolita.
I am for the.
Okay, Mr. S.R. Gogoi. Learned counsel for the petitioner, Mr. M. Kolita, learned
K.
counsel for the respondent, K. Kolita. Learned counsel for the respondent, oil. I have sought listing of the case after person list the case on next week of the.
Item number 59, lordship. It may come up on 21st.
Huh?
Item number 59, supplementary, lordship. Admission.
Yes, what do you want?
It may come up on 21st of February, lordship.
No, it's a silo, 25 or 25. Silo, 25 no, 23 or 26 or did you?
Wait, please, your lordship. Sorry to trouble your lordships. Your lordships, in item number 53, there was an interim.
Interim order passed. I have already dictated.
May I please, your lordship? Lordship, item number 36, interim is there, lordship.
Okay, 36.
Lordship, I am appearing
On the prayer of MS.
F. Begum.
Begum, learned counsel for the petitioner, list the case of February.
Lordship, I am appearing respondent number 10 to 19.
Mr.
SS Islam on behalf of MJ
S.H.
SS Islam.
Jilam.
Islam
Islam. Learned counsel for the respondent number
10 to 19.
10 to 19. 10 to 19.
Yes, Lord.
Okay. Or M. Borman Legal, Learned State Council. The case after 1 week, any interim order?
Yes, lordship.
The interim order passed, shall continue till the next. Itu
Lordship,
punto number itu WPC.
same here in item number 43.
Interim order.
Yes, Lord.
What are these cases?
Hmm.
How 43 cases? No. Okay, on the prayer by MS so please the cases. My concept of petition in 43. And list the cases after 2 weeks. The ATM order past periods will continue till the next.